Right. Serial number 26, madam. I am for the accused. My lord, serial number 20.
Lordship, kindly file an advance application, my lord.
Yes.
Serial number 46. Request a kind permission to mention at 2:30, madam. There is an urgency in the matter. My lord, Udupi municipality disconnect the sewage pipeline. Learn at a single judge, my lord, order reconnection of sewage pipeline within 7 days. However, till today they have not complied the order of learned single judge, my lord. From last 6 months, my lord, my canteen stalled.
We'll take up at 2:30. Just intimate the council for the other.
Please,
Yes.
Your Lordship, kindly file an advance application, my lord.
Pardon?
And 20th, this court granted to comply officer objections. Officer complied, my lord. The urgency is, my lord, 14 flats, electricity is disconnected, my lord. The inmates are finding difficult. From 12th, they don't have electricity connection, my lord. Hence, there's an urgency. From 23/10 date is given, my lord. For Monday, my lord.
For contempt.
I have interim order. Interim order.
Contempt.
My lord, electricity is disconnected.
Read appeal now. Your read appeal will come.
My lord, retapil officer complied, my lord. 20th, this court granted 2 weeks time, complied, my lord.
It will
And the
list it.
date is given 23/10, my lord. It's a long date, my lord. Electricity is not there, my lord.
Move the
My lord,
learned
this.
vacation.
My lord,
You can move the learned vacation. It will come. cannot
liberty be given to move the vacation.
We can't give liberty. It is for learned judge discretion to permit or not. Yes.
My lord, there is a threat of demolition, my lord. I have filed a writ appeal, my lord. The Panchayat development officer has sent a notice on 1st of October. The date is fixed for demolition of my construction, my lord. My lord, kindly have it on 30th, my lord.
Monday.
My lord, serial number 26, my lord.
Serial number 17 and 18, my lord. I appeal for the
79,
17 and 18 in the first list.
17 and 18.
The first list, my lord.
So what do you want?
I am for the complainant. I pray for a week's accommodation.
It will go to 4th November.
My lord,
My lord, the petitioner is a medical student, my lord. She's a student
Pardon?
of GR Medical College. Petitioner is also a student of GR Medical College, my lord. With the cancellation of the license, she has been given seat in Dr. B.R. Ambedkar College. That college is not taking her admission because of the fees, my lords. Madam, I kindly
State college is not?
Is not taking her admissions, my lords. The petitioner had paid 10 lakhs rupees at GR Medical College for her seat. Now the Ambedkar College is demanding 30 lakhs fees, my lords. It's a management quota seat, my lords. Matter may kindly be taken up at 2:30, my lords.
Monday.
My lords, the urgency is this, my lords. The classes have already been commenced and practicals have been done. She's in her 3rd year, my lords. If the admission is not taken up, my lords, that's 2:30.
Monday. One day will not, things will not change.
Monday, my lords.
Monday in the separate court will taken up at 11.
my lord, serial number 26, my lord. I am for the accused in that. I filing the reply to the contempt petition. May kindly have it on
Pardon?
2 weeks time for serial number 26, my lord.
What is the request?
My lord,
What is the request?
filing of reply, my lord. I need time for filing reply.
All right, 22nd
My
November.
lord,
Yes.
Serial number 51, my lords. Serial number 51 is for withdrawal, my lords. My lords, the petitioners have approached the fee regulatory committee. Hence, the petition may kindly be permitted to withdraw the present petition, my lords.
5176.
Please, my lords.
Learned Edward Mr.
Gautam Ayar.
Gautam Ayar seeks permission to withdraw the present petition upon the instructions of petitioner dismissed as withdrawn.
Obliged.
This is a appeal challenge.
Yes,
My lord, civil contempt petition, my lord. A writ petition is disposed of in the month of February, my lord, directing the respondents to deposit the 20% of additional pensionary benefits to my account, my lord. But till today, my lord, no amount has been deposited to my account. Kindly have it on Monday, my lord.
Lord, serial listed, no memo. Serial you want date, will give
No.
of our choice.
Fresh matter, my lord.
So if you want date of posting, we'll get the date of our choice as listed earlier. What do you prefer?
Date, my lord.
Date, 22nd November.
My lord,
Serial number, what?
challenging a petition, my lords. The urgency is that the tender notification has been allotted and the work is about to commence, my lords. The matter could be.
Yes,
listed on
mister, what do you want?
No, my lord, no date, my lord. I'll,
We have said no.
no,
This is court of law.
yes, my lord.
Yes, ma'am.
Serial.
My lord, this is a writ appeal challenging a tender notification, my lord. This is a fresh matter. The urgency is that the tender notification has been completed and the work has been allotted. The work is about to commence, my lord. Kindly, the matter could be listed on Monday, my lords.
It will be listed as per memo.
Serial number 50, my lords. Raise time.
My lord,
It
the
will-
date could be given, my lords, in the.
Date we want, we'll give after holidays.
My lord.
All.
Serial
16th
number
of November.
42, my lord. Serial number
Serial
42
number
is
50, my lords. Serial number 50. Raise time, my lords.
Till number
50. 50.
55,
50, my lords. 50.
50. You want time?
Yes, my lords.
With PIL. What is that PIL?
Foot.
About?
Abandoned vehicles, my lords. Abandoned vehicles.
Pardon?
Abandoned vehicles.
Abandoned vehicle.
Yes, my lords.
So what is PIL in? No, let it be called out.
Serial number
Is no time,
67,
yes.
my lord.
serial number
I pray
42
for
is
withdrawal.
Which one?
Serial number 67, my lord.
67. Learned advocate, Mr. So and so seeks permission to withdraw the contempt petition upon the instructions of the petitioner, dismissed as withdrawn.
serial number
He
42
files
also prepared.
before that. He files memo of withdrawal dated 27/9/24, which is taken on record.
Serial number 42 is also complied, my lord. Kindly it may be dropped the contempt proceedings, my lord. 42, my lord.
42.
It's
What do
complied.
you want?
My lord, it's complied, my lord. Kindly it may be dropped the contempt proceedings. I am appear for complaint.
Drop. So it has to be dropped. Learned advocate, Mr. Mukappan has stated that the order under contempt is complied with.
Yes,
Therefore, the proceedings may be dropped. In
Much
view of
ob-
the statement that the order is complied with, the petition is disposed of as not surviving.
much.
Your Lordship, serial number 49, Your Lordship, I appear for respondent number 5 in this matter.
Yes,
We are seeking for a
49. What is the request?
if the matter may be listed post vacations, Your Lordship,
Pardon?
we the senior counsel, Your Lordship.
What is it about?
Your Lordship, it's with regards to
What is
pollution,
it about?
pollution, Your Lordship. And the reports filed by respondent number 4, which is the Pollution Control Board, also showcases that we are compliant with pollution standards. If the matter may be taken up post vacations, Your Lordship, we've engaged a
21. It is PIL of 21. Let it be called out. Then we'll
indeed.
consider whether to grant time or not. Yes.
List number 2, seal number 1, Mr. Abhishek Mali Patil.
Filing a statement of objections.
Told or not?
No, my lords, they have, issued an endorsement yesterday. my lords.
Endorsement, she's not entitled.
Not entitled.
Not entitled for,
Can you challenge that
I'm
endorsement?
finding.
No, my lords, I have a difficulty, my lords. I'll challenge that, my lords, endorsement, but kindly see the endorsement for a moment.
Well, my statement of objection.
What is your filing?
Now I'm filing.
Now, this is by petitioner.
Yes.
There's a principal misunderstanding of the law, my lords, by the KEA. What are the requirements under law? When the translated version of the Karnataka government order becomes relevant, my lords, may kindly peruse that as well, my lords. I have produced the translated version also, along with the endorsement. In the endorsement, they refer to a government order. The translated version of the government order, my lords, also is there.
In the background of.
Yes, my lords. That, my lords, gives the, my lords, what is the requirement under law. My lords, it only says, the government order.
Read it.
Yes, my lords. In the background of the points outlined for the proposal regarding the student seeking admission for the academic year 18 and 19 onwards in state undergraduate, postgraduate, medical and dental course for 18 and 19 under the linguistic minority reservation, field education officers in respect of students studied in class 1 to 10 and 11 and 12. In respect of equivalent studies, deputy director has been appointed as competent authority to verify the confirmed information provided by the heads of the concerned institution and to issue linguistic minority certificates to candidates. The said authorities are required to issue certificates as per Form 5 and 5A respectively. Form 5 and 5A has already been placed on record. My lords may kindly see annexures. It only needs to say, my lords, the authority is only supposed to say what my mother tongue is. It does not need to say, my lords, whether I've studied from first standard till 12th standard in the state of Karnataka. The requirement of a linguistic minority certificate
This
is.
is based on some rule,
Yes, my lords. The government order,
Government order.
not based on a rule, my lords.
which you read.
Yes, my lords, is a portion of the government order which is extracted, my lords, in the
No.
endorsement. My lords, in the endorsement in page number 2 in my memo, my lords,
Studies from class 1 to class 10 and class 11 to class 12.
2 authorities are designated to certify regarding that. That's the differentiation that is being made between.
But Mr. Ramesh, you are not supposed to accept the certificate.
We have to accept this because, Lord, as far as minorities are concerned, as per the Honorable Supreme.
Which is this competent authority who's this certificate?
The school has to give and the it should be countersigned by, my lord, the BEO. That is
Not the school, my lords. The form is to be certified by the authority. School does not issue the form. The certificate has to be issued by the authority.
Deputy director.
Yes, my lords. 2 authorities are designated. Both of them have, my lords, given me the certificate, 5 and 5A. My lords, placed it on record.
Page.
Annexure, my lords, E2, my lords, 44. Annexure 5. E2, my lords, are in page 44, my lords, in the writ petition.
Page 40.
Which certifies, my lords, the first authority certifies that my mother tongue is Telugu. Second, my lords, 5A is in next page, my lords, 45. There is a misunderstanding, my lords, by the KEA, assuming that, my lords, the annexures that the certificates that I produced at annexure B, which is study certificate for a period of 10 years, is juxtaposed with these certificates.
But the certificate, the format of.
Study certificate is different, my lords, and the linguistic minority certificates, there are only 2 certificates that are supposed to be given, which are already placed on record. The fact that I'm required to study in the state of Karnataka for 10 years, my lords, also is certified by the very same authority, my lords, at annexure B.
They appear that in 12th standard, you are not.
My lord,
My lords, my mother tongue, my lords, not the medium of study. My lords, this question your lordships posed the other day to the KEA, whether the medium of study has to be Telugu or the mother tongue. My medium of study has got nothing to do with this certificate, my lords, only my mother tongue. Mother tongue need not be certified by, my lords, every school.
it has to.
In terms of the rules only say 2 forms. 2 different authorities have to certify what my mother tongue is. 2 different authorities have certified, my lords, my mother tongue. And the other requirement of the rule is, my lords, that I should have studied 10 years in the state of Karnataka, which is also certified by a separate certificate, my lords, at annexure B. My lords, annexure B also may kindly be seen. My study certificate, my lords.
Oh.
That is what we want to see. Where is the rule or government prescription?
Yeah, my lords, there is no government rule regarding linguistic minority. It is only through an executive order of the government, which also, my lords, specifies in the way that, my lords, I am projecting to your lordships. It does not, my lords, the understanding of KEA is wrong.
No. Word mother tongue.
My lords,
Where is the word mother tongue?
in linguistic minority, my lords, linguistic minority certificate. It says linguistic minority certificate.
My lord, my learned friend is completely, my lord,
is in annexure 5A, the second authority which is supposed to give for 11th and 12th standard mallots. That is the authority. A different authority mallot certifies that, linguistic minority.
You studied for first to sixth.
First two mallots all the way 12th in Karnataka.
First to sixth standard, you studied where?
Mallots, first to third standard mallots, I studied in a different school mallots.
First to sixth,
First to third mallots.
third. Wow.
Yes, mallots. That's a certificate also I've produced here, mallots. Annexure A, annexure B. This is the study certificate, mallots.
Basic certificate.
The requirement of study certificate to show mallots that I have studied 10 years in the state of Karnataka mallots is at annexure B.
Page,
Annexure B, ink page 15 mallots.
page 13.
15 mallots, 1-5. Certified by the authority as well, mallots. First to third mallots, third to sixth mallots, and 7th to 10th, and 11th and 12th separately, mallots. All certificates are placed. Mallots, they seem to understand, mallots, that these two certificates will have to be merged. Mallots, the study certificate as well as the linguistic minority certificates have to be merged.
I consider. Now, certificate 15 and 16. Does it indicate that the student studied in Gujarat?
The basic certificate is what to.
Did it suggest that the student studied in Gujarat? Gujarat.
Gujarat. No,
Does it suggest that student studied in Gujarat?
no, it is not the question.
So it is obvious that he studied in Telugu.
Yes. Well, linguistic minorities, as per the Supreme Court, state has to be taken as a unit. And
About their status of linguistic minority, there is a dispute? There is no dispute.
Because the specification is not there.
What specification?
My learned is misleading with regard to the government order. I have the full government order.
All right, according to you, what is the requirement?
1 to 10 has to be studied in Karnataka, and if the format is given.
So 1 to 10 he has studied in Karnataka.
They have to give a format, 1 to 10 as well as 11 and 12. The format should be annexure 5 and 6. That color is not showing.
Where is that?
Brochure itself it is there.
Where is that format?
That is not showing. Formally observed for everybody, my lord, my learned friend can't be an exception to this. My lord, your lordship may, in this brochure, first your lordship may take page 34.
Page 45 is as per annexure 5.
No, for 1 to 3, it is not there. Now your lordship can, I'm sorry, my lord, this thing is in Kannada, my lord, the government
That
order.
I have translated. It does not require, mallots, is what I'm, my contention.
The
Because
government,
as per the government order, Form 5 and 5A need not, my lord, say from which year to which year. It only certifies my linguistic minority status. Study certificate, my lords, is a separate certificate which shows, my lords, I have studied from 1st to 12th standard in Karnataka.
the government order has to be
It does not
seen in
say.
full. He has not produced that. My lord, it's in vernacular, my lord, I will, if your lordship permits, my lord, I will have it to Monday, my lord, I'll translate it. For the time being, I'll just give, my lord, what is the specification, I'll mark it also in the government order.
That's extracted in the endorsement, which is translated, my lords.
Because, my lord, if this is to be accepted, my lord, anybody who has not give a certificate without, my lord, 10 years of study, and in the basic certificate showing mother tongue as Telugu, or whatever mother tongue.
But here it is as clear as daylight.
In 1 to 3, it is not there. Your lordship can kindly see annexure A, annexure 5.
Format it is not there.
In format, it is there.
So in fact, it is there.
In our format, it is there. The Telugu should be mentioned. The certificate which he has given for 1 to 3, it is not there. What prevents, my lord?
Format it is not there, Mr. Ramesh. In the format it is not there.
No, he has not given the format at all.
In fact, it is there.
In the format.
One can readily read it or see it that he or she has studied in Telugu.
No, your lordship kindly take the certificate of 1 to 3, my lord. I'll just, that is in, my lord, page.
Probably the requirement is of linguistic minority only.
Page 15, your lordship, kindly see.
Page 15.
Page 15, Annex B, there is a certificate which he has given. This is not in format.
This is not in format, the correct.
No, that is not in format, one thing. And this doesn't say that mother tongue is Telugu. That is not there in this. In page 15.
So he studied according to in Gujarat.
No, not studied. The mother tongue is Telugu. Mother tongue should be the criteria, my lord.
Studied in Tamil. Tamil.
No, that my lord, he has to produce. He has to produce. Not burden is not on me.
Student who has studied in first to three standard is supposed to have studied in mother tongue, unless you demonstrate.
No, not mother tongue. It's not necessary, my lord.
It is not necessary.
It is not necessary.
Only necessary.
study in Karnataka.
Status of linguistic minority.
Yes.
Yeah, yes, but for the status of
They are asking the query only since you are taking suggestion. That is also not necessary. The necessity is the status of linguistic minority.
Well, that is the purport of the government order. But I have produced the just. Your lordship, kindly see the government order. It's in Kannada. I'm sorry, my lord. It's here. Your lordship,
Translated by Hussein.
Yes, Manoj, same
the
thing.
full translation is not there. I'm sorry, my
That
lord.
portion which they have extracted is translated.
No. Lordship, kindly see preamble. I'm sorry, my lord.
Come on, copy.
Lordship, see the preamble, my lord. State government issued this notification to ascertain the indicia with regard to the, my lord, the status of a minority. That is the reason, my lord, the state government has issued that notification. In that notification itself, this 5 and 5A has been mentioned. In format 5A and 5 and 5A, they have to certify that the school has to certify, the school authority has to sign down below, my lord, in the institution, and also, my lord, the BEO has to countersign it. Both is not there as far as first basic certificate is concerned.
is accepted. They are disputing other thing. First, because in the certificate.
And my lord, she is studying, my lord, in, she is in, my lord, Kolar district, in Mulbagal. Nothing prevents her, my lord, to go to the school and get the certificate. She doesn't want to give that certificate for the reasons best known to her.
Still, we are not clear that what is your requirement.
Requirement, my lord, is, my lord, Form 5A and 5, my lord, Lordship, kindly see.
Format I didn't forget for, what is requirement in substance?
Substance, my lord, one.
Okay, as your endorsement that he must be belong to linguistic minority.
For the inter-alia, my lord, he should have studied from Form 1 to 10 in Karnataka.
That is
That is one thing. That is one thing. And, my lord, her mother tongue, as mentioned in school record, should be the linguistic minority mother tongue. These are the two, my lord, this thing in the government order.
It is also stated as certificate.
No, it is not stated. 1, 2, 3 certificate, your worship, it is not stated that.
1, 2, all right.
Because that is the basic certificate. That is the basic certificate from the school. All other certificates, my lord, on the basis of the school certificate, my lord, they issue. Any parent, my lord, when admitting the children to the school, first, my lord, they say what is their mother tongue. That has not been mentioned in 1, 2, 3. That it is not there, perhaps. They have managed to get these certificates now subsequently. Otherwise, there shouldn't be hesitation, my lord, to get a certificate from the very next door, my lord, of their where they are staying. Even now, if they get that certificate from that school, my lord, we'll give the seat to them. Because all that certificate might be, my lord, they're higher in ranking than the petitioner also. And now, your lordship may also kindly see page 16, my lord. Page 16. This study certificate, my lord, here it doesn't mention, my lord, the mother tongue as Telugu. She got it corrected by producing the correct certificate, which is at page 43 in the format itself. Page 43, your lordship, it is signed by the head of the institution, also countersigned by the BEU. Same certificate, class 4 to 6. Same certificate. Otherwise, my lord, it leads to misuse of, my lord, the linguistic minority quota. If the mother tongue is not mentioned in the very first, my lord, 1, 2, 3, and my lord, subsequently they mention. That's the reason government, my lord, in its wisdom, they specifically say 1 to 10 should be studied, and they have to say that their mother tongue is students.
Linguistic minority is defined.
Linguistic minority, my lord, is defined, my lord.
I think it's defined.
It's under the Constitution, Article 30.
The argument is defined.
Article 30, my lord. Article 30. That, my lord, if I have to go to that, my lord, I have to go to the TMFI in, my lord, where who is a linguistic minority? A linguistic minority in one state cannot be a linguistic minority in a.
Who is linguistic minority for the purpose of Telugu?
Not Telugu, my lord. It is a linguistic minority.
Any linguistic minority. What is the criteria?
Guidance is, my lord, first thing is, as the Supreme Court said, first you take the state as a unit for the purpose of, my lord,
Get every law.
yes.
What does the common sense
Constitution says, but there should be a minority in that particular state. Linguistic minority in that particular state. Then what is the indicia? How to say whether a particular person is a minority in that state or not? Merely because he says it is not necessary. 1 to 12 might have studied. But a person from, as your lordship said, Gujarati can come and study 1 to 10, even 12.
In the status of her status as linguistic minority.
Yes, for that, the government order comes into play. The government orders is on the basis of the Supreme Court judgments. As your lordship rightly put it, my lord, there was no, my lord, indicia to say a particular person is a minority. Or that is the reason, my lord, the preamble says that. That's the reason they brought in this government order. And these two, my lord, pro formas.
Hard learned advocate, Mr. Abhishek Mali Patil. Mali Patil,
Mali Patil.
what is your name?
Abhishek Mali Patil.
For the petitioner. From learned additional government advocate, Mr. Sudhir Hegde, for respondent number. You are there, party?
Yes, yes, there, because it's their notification.
For number 2 state. And learned advocate, Mr. Interim for respondent 1. Karnataka Examinations Authority. So you are appearing for 2, 3, and 4 all.
2 and 3, my lords, 4, my lords.
What is the college?
2 and 3.
Yes.
And learned advocate, Mr. N.K. Ramesh for respondent Karnataka Examination Authority. Paragraph. The petitioner aspires to pursue the course of MBBS. The prayer made in the petition is to direct respondent Karnataka Examinations Authority into Brigade KEA to confirm the allotment of MBBS seat in category 2 capital A at the Oxford Medical College, Hospital and Research Center, Bengaluru. Petitioner claims the eligibility for pursuing this course as belonging to linguistic minority. Linguistic Telugu speaking minority. The case of the petitioner, in the petition has been that the seat was allotted in favor of the petitioner in the first round of counseling. And also in the second round of counseling. From that, in the second round provisional allotment result, in the second round provisional allotment, the results were declared on 18/9/24 by the KEA. Petitioner was not permitted to read the formalities. It gave cause of action to the petitioner to approach this court by filing the present petition. when the petition was taken up at the first instance on 25/9/24, learned advocate for the respondent number 1 KEA appeared upon the receipt copy of the petition in advance, and it was submitted on behalf of KE that the petitioner was shared to satisfy the authorities about the holding of some certificates to show that she studied in the state of Karnataka, as also the certification by the school authorities showing that her mother tongue is Telugu. Court directed the court required the petitioner to approach the authorities, produce the certificates. Petitioner approached the authorities and produced the certificates, which are also annexed as part of record of the petition. Today, when the petition came up for consideration, further consideration from a learned advocate for the respondent 1, filed statement of objections and produced an endorsement dated 26/9/24, issued by the executive director of the KEA, treating the petitioner not eligible. The case of the respondent KE is that certificates are prescribed in proper format, certificate 5 and certificate 5A, and the necessary information is to supplied by the petition, the candidate, in the format. About the status of the petitioner to be belonging to linguistic minority, linguistic Telugu minority. And that she studied in the state of Karnataka, the following stand is taken from extracting paragraph 3 from the statement of objections and quote paragraph 3 in the certificates produced by the petitioner. Then is the basic certificate. The endorsement paragraph. Treating the petitioner to be not eligible from when prima facie sin, it is stated that in the linguistic minority reservation, the linguistic minority reservation is applicable for Tamil, Telugu, Kodwa, and Tulu of Karnataka candidates and domicile candidates. The second requirement indicated, the second requirement mentioned is that he or she should have studied in Karnataka for a period of 10 years from first standard to the qualifying examination of 10th or 12th standard in the state of Karnataka. Paragraph. Admittedly, the petitioner has produced 2 certificates which are annexed file. Where is that certificate?
Annexure 5 and 5A is at an
Page.
page, my lords, 44 and 45, my lords.
Produce two certificates. Interpreted Annexure E2, page 44, and Annexure E3, page 45, issued by the principal of the school. The first certificate dated 29/1/24 mentions that the petitioner studied from 7th standard to 10th standard, and that in such study, her mother's tongue was Telugu. The second certificate is on the same lines to indicate that in the study undertook by the petitioner in 11th and 12th standard, the mother tongue of hers was Telugu. There is no dispute about the fact that the petitioner has studied in the state of Karnataka. From 1 to 12 standard. The objection which is coming forth in the order treating the petitioner to be ineligible is that the aforementioned two certificates cover the period of 9 years instead of 10 years to show that the petitioner studied in language and that the mother tongue was Telugu. It was submitted then. The pro forma number 5 and 5 capital A, in which certificates are required to be issued, has to be satisfied. It was sought to be submitted that it is not mentioned in the certificate that the petitioner's mother tongue in the first to third standard, first to third standard was Telugu. The requirement paragraph. The requirements emphasized as above flows from government circular dated 12/9/18. Full stop. Produced in vernacular, the contents thereof was explained to the court. Admittedly, it contemplates two requirements. First is that the mother tongue of the student should be Telugu, as is instance case. The second is that the candidate students should have studied in Karnataka from first standard to 12th standard. Paragraph. When the petitioner has been admittedly able to establish that he studied from 1 to 12 standard in state of Karnataka. And secondly, her mother tongue in all the standards from 7th to 12th was Telugu, comma. It follows as necessary sequitur that as a student of standard first to 3, her mother tongue was Telugu. This is more particularly in view that nothing contrary is produced to rebut this full stop. We stand that in the format of 5 and 5A, comma, this fact is not from the form number 5 and 5A, this factor of Telugu mother tongue of the petitioner in standard 1 to 3 has not been emanating, and therefore the petitioner could not be treated as belonging to the category of linguistic minority, Telugu minority, comma, is too hyper-technical to be countenanced at this stage. Full stop. A strong prima facie case is made out for the petitioner. Paragraph. Rule returnable on December 2024. By interim relief, it is directed that the petitioner shall be permitted to complete all the formalities for securing admission in the first MBBS course on merits in the quota of linguistic minority, Telugu minority. Full stop. It is however provided.
At the respond number 4 institution. In the respond number 4 institution. It's already allotted in the respond.
In respect of the seat, which is already allotted.
Allotted.
To petitioner in this 4 institute.
Yes, Mr.
However, it is clarified and observed that the admission which may be given to the petitioner shall remain subject to final outcome of the petition.
Grateful. Grateful.
Seven to 12 Telugu instead of standard 4 to 12 Telugu. There are two certificates.
Two years.
It's really-
Great.
Cell number 2, Srimati Sudhadi.
Here for appellant. Lord, appellant is a former employee of
What is the urgency?
urgency, my lord, that the entire pension is withdrawn. Entire pension is withdrawn and suffering for the livelihood. My lords, even another aspect is that, my lords,
All matters are urgent, but what is the urgency to?
yes, now my lords may be pleased to, only my request today will be direct the notice to the learned council who has,
No, no. For that, you are getting the matter listed in a special board.
no, I'll submit it.
We are making it clear that any matter mentioned and get placed in the separate board in this last week, where the court is running short of time.
Please,
Urgency is not found and the mentioning is misused. This will go after 3
no,
months.
it was.
It is
not- No, it was not like that, my lord,
not going to,
maybe immediately after,
after vacation, 22nd of October.
please.
Cell number 3, Mr. Chandrachud A.
Yes, what is the urgency?
But I have sought for extension of time for implementation. Not very quickly, if I may explain the background facts. By an order dated 22nd June, your lordship had partly allowed my writ appeal. Not the issue was regarding payment of the NFFU. Whether two questions, whether the appellant, the respondent is eligible, and if yes, from what date. Lordships partly allowed my writ appeal and directed that the eligibility is from 12/12/2011. 3 months' time was given for implementation of the order. Now, my lord, there are some.
No, what was the dispute?
Lordships have partly allowed my appeal, directed payment of the amount with effect from 2011. Lordship had granted 3 months' time for implementation.
So
Lord, now there are similar matters pending before the Delhi High Court and the Honorable Supreme Court. Lord, we will take a call whether we have to challenge this or not, because.
Okay, this is IA number 3 of 20.
Yes, Lord.
Heard learned additional solicitor Mr. Kamath for the applicant and learned party in person. just the original petition. The application was filed, whereby the prayer is made to extend the time to comply with the order, judgment and order dated 22/6/24, more particularly with regard to the direction contained in Roman small 3 about payment of benefit, Roman small 2. About the Roman small 3 regarding it of the receipt of the copy of the order. It was stated that 3 months have passed from the date of the receipt, however, for the reasons bona fide, the compliance could not be acted upon. Time of.
It was out 3 months.
3 further months was paid for. Extension of 3 further months to comply with the direction and to pay the, and to settle the dues of the petitioner is paid for. The persons of case and in view of what is stated in the accompanying affidavit with the application, the further 10 weeks is granted to the applicant to comply with the direction.
I'm grateful.
Number 4.
For the petitioner minutes.
This is regarding the matter pertaining to the
IS 3 is for what?
ours is IA number 5 for vacating, my lords.
5 for vacate.
IA for
The
5 for
the
vacating.
order was granted in IA2, my lords.
3 for what?
IA2 had been filed by me.
5 vacating.
IA5 is for vacating the order which was granted in IA2.
IA2 is for stay. IA2 for stay, which is grant.
We are dealing with IA 3 and IA 5.
Well, it's IA2 and 5.
IA2 and 5.
2 and. So 2 is for stay.
Stay.
Please, my lords.
Where stay is granted.
Correct,
Yes.
correct.
Stay was granted on 12th of June 2020.
Where is that order in IA 2?
12th of June 2024, my lords.
My lordship, the last paragraph of the order dated, my lords.
12/9.
12/9. 12/6. 12/6, last paragraph. IA number 2 of 2024. In IA number 1 of 2024, your lordships were pleased to grant permission to BMRCL, my lords. In IA number 2, your lordships were pleased to grant stay of not to fell trees. My lords, God, can I give a copy, my lords? What of this? Copy. 12/6. 12.
I have a certified copy.
And that is regulated.
Our learned The committee will revisit the.
Revisit,
Committee member.
please, my
TEC.
tree expert committee, Manoj.
Who are the committee?
The TEC is a committee that has been formed under the orders of this court.
Orders of-
Please, Manoj.
That orders are available.
They're all, I have in fact filed a convenience compilation with all the orders of the honorable court. There are about 30 orders that have been formed, that have been passed.
Heard, learned. Near advocate three. Speaker on section. Behalf of.
Respondent number 11.
The applicant rail infrastructure development company. Integrated Karnataka, bracket over. LTD. Integrated K days right. Which is the applicant in interim application number 5 of. That's original, this one number 11. There. Of the applicant in this application is to vacate. Order. Dated 12/6/24. Passed below application number 2 of 24. In the proceedings of writ petition. This was the stay against BBMP.
No,
Please.
against us, Manoj. BBM, we are not made party, Manoj. K-Ride was not made a party. So we implemented ourselves as respondent number 11, which your lordships allowed, Manoj. Because ultimately, Manoj, it is order against us.
The said order dated
12/6.
12/6/24. Required the respondent Brahat Bangalore Mahanagarpalika stop the felling of trees. So stated paragraph that the applicant corporation
Please,
Please, Manoj.
respondent number 11, corporation.
for applicant development company
Oh,
was not a party in the main writ proceedings, which came to be subsequently implemented
Please.
as respond number 1.
11,
11.
11, 11,
11.
11.
Since the aforesaid order dated 12/6/24 was passed by the court prohibiting the felling of trees. The present ticket is filed by the applicant corporation seeking clarification and vacation of the state order seeking permission to fell the trees for its project. Learned so. Learned secretary for the applicant and learned advocate Mr. So for Sayed Shahrukh for, no, what's the good name?
Pradeep Nayak, Manoj.
Pradeep Nayak, the original petition. Paragraph, it will be noted that the main petition came to be filed by the Bangalore Environment Trust, wherein the directions were sought for against the respondent authorities to discharge their functions under the Karnataka Procedural Trees Act 1976 and Karnataka Reservation of Tree Rules 1977. Is also to adhere to guidelines set out by the judgment of the Bombay High Court in Public Interest Litigation number 93 of 2009. It was also read that in every case where the permission is granted to fell the tree, all efforts should be made and it should be ensured that against one uprooted tree from a new 10 trees should be new tree shall be planted at the same site, which is the requirement contemplated under section 8 interpreted 5 of 1976. Paragraph. In the proceedings of the said public interest petition from this court passed orders from time to time, including the aforesaid order dated 12/6/2024. It is to be noted that before the aforesaid order dated 12/6/2024 was passed, the applicant development company is invested with the order dated 29/5/24 passed by the tree officer and deputy conservator of forest, Bengaluru, Mahanagarpalika, and BBMP, Bengaluru, whereby subject to the conditions mentioned in the order in this petition, the permission is granted to the applicant company to cut
Page 23, madam.
about 699 trees in execution of its project. The project is known as design and construction of elevated viaduct. This is page. Buildings for corridor of two. In the application paragraph seeking to permit the filling of the as per the said order dated 29/5/24 and to vacate the order dated 12/6/2024 which may operate against the applicant company not to permit it to sell the trees, it is the case that the applicant company is a joint venture of the government of Karnataka and Ministry of Railways, which was constituted under the Companies Act 1956. It is established to enhance the rail infrastructure projects Karnataka and is responsible for executing the Bangalore sub rail project. It aims to make available world-class rail infrastructure. the applicant company is an implementing agency for the aforesaid Bangalore Suburban Rail Project into bracket BSRP. It stated that the process of execution of the BSRP project by the applicant has become necessary to remove trees standing at the project area. It is stated that applications are submitted to the authorities in this regard, which are processed and considered. It is stated that the applicant will be abiding by all norms and procedures. Paragraph. The civil works which are the kind and nature of civil works, which is to be required to be undertaken and executed by the applicant in completion of the project. Completion of the BSRP project is detailed in paragraph 5, which is reproduced for bring out a clear picture of the nature of work required to be executed by the applicant. Paragraph 5.4. Where are the orders? Orders, it is to be noticed that by orders dated 23/4/19 and 3/9/2020, this court has constituted an expert committee which comprises of the
Page 46.
The committee
42.
examines the feasibility for felling trees and compliance with provisions. Trees Act and the Trees Act 1976 and Rules of 1977. Committee consists of the experts, field of environment, science, technology, and other related fields. Only one is there. Correct. No problem. It is in light of the aforesaid, the committee, the said committee paragraph. The applications were made by the applicant before the said committee to permit it to remove the trees in the area of the project. The application resulted into order dated 29/5/20. It is this order which the petitioner seeks to implement by praying that the prohibition against felling of trees provided for by the court in order dated 12/6/24 may be lifted. Paragraph. The court has gone through. Court was taken through the
Official memorandum.
relevant material produced with the present application, including the contents of the memorandum dated 29/5/24, whereby the tree officer has granted permission to the applicant to cut 699 trees. Full stop. While the court noticed from the said memorandum dated 29/5/24, that while permitting to cut and remove each of the 699 trees, the committee has given its tree-wise recommendation. In all trees listed with the name and description, the recommendation are provided with reasons its weight with the committee to permit the removal of the tree concerned paragraph. However, on a closer examination, of the
Page 63.
list of the trees contained in the memorandum and the recommendations, it could be noticed that trees mentioned at
101 to 110 to 507, page 63 to 78.
serial number 110 to 507, as well as the trees mentioned from serial number 605 to 646.
Please.
Do not contain for their recommendation any reason. The committee has only stated that the state trees are coming. The committee has only stated in its recommendation against each of the aforesaid trees, only that the tree is only that comma inward comma tree is coming in proposed viaduct via DUCD area, comma recommended for felling, full stop. Therefore, when no reasons are given for recommending the felling of the tree, comma, the decision of the committee and the resultant office order dated 29/5/24, insofar as it relates to trees at serial number 110 to 507 and those mentioned at serial number 0605 to 646 could be said to be without application of mind, full stop. In the aforesaid review, comma, it is not permissible for the court to permit applicant to proceed with felling of trees which are mentioned and permitted. Tree officer at serial number 110 to from serial number 110 to 07 and from serial number 605 to serial number 646 in the office memorandum, full stop. The applicant shall not cut the said trees without complying with conditions which are imposed.
The expert committee has to.
Herein below, full stop.
Please.
In the aforesaid review, the following order is passed, comma, the review committee shall revisit each of the above trees mentioned at serial number so and so, from so and so to so and so and to from so and so to so and so in the aforesaid office order dated office memorandum dated 29/5/24 and examine the again and re-examine the feasibility and desirability of feasibility and permissibility for felling the said tree, full stop. After undertaking the inspection and examination as above, from a separate order shall be passed with reasoned recommendation as may be thought fit by the advisory committee. Also, the exercise shall be completed within a period of
15 days, man, by 15 days. Man.
oh yeah.
That they actually they can do it within 3-4 days, my lords. In fact, we have verified from them, my lord, the tree expert committee. They said actually
Within 3 weeks. Within 3 weeks. Looking to the total spread of the area. Full stop. A fresh orders will be passed by the tree officer based on the recommendations of the tree committee. Rest of the trees, except above numbers, are permitted to be cut, are permitted to be removed by the applicant, if found to be falling within the project area by complying with the conditions which are already mentioned in the office memorandum dated
29/5/2024.
9/5/2024. They are reproduce the conditions. They are found at page 23 and 24. Okay. In the event, the advisory committee, the tree felling committee permits the felling of further trees, it is the committee may impose any other condition, including the above conditions already imposed. So, the present application is allowed in part to the aforesaid extent. The present order governs the interim application number 2 of governs to modify the order dated 12/6/24 asked in interim application 2 of 24 as well as the present application which is allowed in part.
I'm grateful to my lord.
If I may make two more small requests, my lord. One is that this court has repeatedly said that in exercising their powers, they should make every effort to save each tree. That has been repeatedly said. If your lordship would also, when they're re-examining this, any tree that can be saved.
Referring to 1 tree versus 10 trees.
No, my lords. If out of these 450 trees, any of the trees can be saved, they should try their best to save the trees. That's the only request, my lords.
It goes without saying.
Please, ma'am.
Said that recommendation.
If an OM is passed, my request is that they may place it before this court before they fell any trees. Because it should not be that the same happens and then they start felling the trees without permission of this court.
Response number 11, the applicant of IA number 5 of 24 shall place on record the recommendation and the consequential order, if any, which must be passed by the review officer pursuant to the aforesaid direction and the extent.
Please, Rashmi, can you give a
Exercise to be undertaken as per the directions. of
Please,
the-
ma'am.
can a date be given so that we can place it and close it?
We'll keep it on this, we'll keep November, 7th November.
Deeply grateful, Ms.
October, it will be actually, Manoj, they require actually 1 week or 10 days, they'll finish it. Earlier date around the 20th of October itself, Manoj. Any date,
20th October,
please,
21st October.
please. Manoj. It's
Monday, 21st. 21st is Monday.
21st, Monday.
All the issues which are raised by the public interest petitions regarding the feasibility, desirability, and feasibility, desirability, and advisability of felling trees to protect the environment shall be considered in the next proceeding.
Deeply grateful.
So that it is alive.
Absolutely. So 21st October onwards. Grateful to.
Next proceedings as per the convenience of the. Don't say that we'll proceed on.
My lords? As I also want to place on record my gratitude to the Advocate General, Manoj. After he came, he ensured that
Manoj, if something is wrong, Manoj, we should point out and.
He is always.
Absolutely, my lords. It should not go unsaid that the petitioner is grateful.
He is always very.
Please.
I'm
Grateful,
grateful to, grateful to him.
Number 5, to Suyo Gerele. Here for the complainant.
This is the matter
Date
where
of
your
hearing,
lordship
my
is
lords,
supposed to
on
handle.
29/24. The lordships had passed an order, my lords, directing them to hand over, my lords, the charge of the temple.
What?
When the officers have gone there, the complainant has traveled to America. He is not there.
My lords, tomorrow, my lords, he will be coming, my lords. On Monday, I will go and take charge. My
Put
lords.
up on 14th of.
My lords, may I request on Tuesday, my lords, it can be closed. My lords, Monday we will, my lords.
In the due course of time, whenever he comes, we'll hand over the charge.
We'll say that it's process of compliance.
Yes.
Learned advocate, learned additional government advocate, Mr. Jafar Shah. Order of learned single and the subsequent orders passed by this court in connection therewith in the present contempt proceedings, including order dated 20th/9/24 are in the process of compliance. Send over to 22nd October.
Lords, may I request an earlier date, my lords. May I request any earlier date, my lords.
Earliest is 22nd. What early? 18th October.
Please, grateful.
Grateful.
Yes, now. How matters, so many matters. Yes.
For respondents, I pressed them to file reply in this matter.
For complaint.
There was a direction to reinstate the complaint. And
So what do you want?
my lord, I pressed them to file reply in this matter. My lord.
Why it is kept in this? Why did you get it kept? The second board all day. 23rd November.
Please.
On the last date of hearing, my lord, senior friend has not appeared. Therefore, it is in second list, my lord.
He is seeking time. Any objection?
No.
Then, yes. next.
Number 7.
Dean Nagraj.
On third, my lord directed notice to the pollution control board. On fourth itself, I served copy.
He is saying no, then beyond witness.
No,
Only you said there is touch and go matter, therefore we have kept.
notice has been served to him. My lord. On
Notice
fourth-
has been served. The issue is that, my lords, 4 of the industries, my lords, out of the 7 petitions.
So not possible to be argued.
Lord, my submission will not in this case, my lord, kindly see, my lord, in first matter. Just
That's
one
again
order I'll
disposed
refer.
of. Let me suggest something, my lords. It can,
No, kindly see, my lord, one submission, my lord. My lord, earlier occasion, my lord, similar order was passed. My learned friend appeared. That order was without notice. My learned friends considered that, my lord, they will issue notice and they will pass orders. Again, but they have passed closure order without notice.
He wants to argue your matter, then what can?
My lord, my lord, there are 7 industries closed, my lord, since 3 months, my lord. I will request only a little earlier date.
May
Learned, you want to file some reply?
Objection, let them not fail.
Can I make one suggestion, my lords? If he wants to get it disposed of, let it get disposed of, treating it as a show cause notice, no problem, my lords. Let them not operate until the matter is disposed of. That's because, my lords, 4 of the industries do not have consent.
But
they want to operate.
wherever consent is not there, will not operate.
No, no.
Wherever consent is there,
The
will.
second-
Otherwise, my lord.
That's my past.
So in 4 industries, there is no consent, my lord.
Some order is passed.
Easier for my lords.
Wherever consent is there, let them operate.
Either number 7, no. It's a job.
Where is the order?
My copy is gone.
Some order was passed in their group of petitions.
No, that's a
That is
different,
different.
that is environmental compensation. my lords.
That is different.
This is, my lords, where they don't have consent. They've come before my lords and we have closed down them. Now they want to operate it, my lords. That is number 1. Number 2, 3 industries have to be complying with an SOP which is being issued by CPCB. They've not done so. So all the 7 industries, my lords, should comply. Until then, let them not operate. We will hear them, my lords may pass any instruction on the time frame.
My request, my lord, one submission, my lord. But they issued a new SOP on 60.
Was not after hearing you.
No, my lord, no notice, my lord. No notice, my lord, existing industry.
They were heard.
I'm very sorry, my lord, this is not correct. My lord. This is not correct.
I'm making a statement. They were heard. They submitted their reply. All of it is featuring in this particular.
And if that is so, if that is borne out from the record that they were heard, then we'll send back only upon your statement, not the another one. Are you making a statement that?
No, my lords, I'm making a statement, my lords. Let it go back, my lords. If they let it go back to be treated as a show
Let it
cause.
go back. Go back is our job. Are you making a submission that they should be heard again?
No, my lords, I'm not making it.
Then let it be argued. We are not here to give concessions. to
No,
people.
no, I am not saying, Lord, on the face of the record, Lord, they have not heard. I will show him, Lord, I will show him, Lord, on the.
We'll take our merits.
No, kindly see, Lord, one line, I will take, Lord, kindly page number 31 in the first matter.
Thirty-one.
31, page number, the impugned order.
Yes, that is impugned.
There are 11 references there.
Correct. So you are not heard?
No, my Lord, notice has not been given. This is my main grievance.
Lords may see the title of it, my lords. I don't know why my page 31, cancellation
Yes.
of abeyance of the closure order issued. Closure order was issued back in the year 2023.
I will give date, my Lord, I will give date.
My
5th
lords,
August, my Lord, kindly,
They
sorry,
will comply.
There was issue. They were heard.
kindly see,
No,
Lord,
no,
no.
after being heard, a closure order was issued. They said they'll comply. We kept it in abeyance. They're not complying. We issued a notice. They replied
is
to
not
it. My lords may see serial number 11 and page number 31.
Hmm.
8/7/2021 industry issues a letter. My lords, I'm only saying that, my lords, these industries are highly polluting industries because they're recycling tire.
Or what do you prefer? You want to proceed or you want to get it done with? You want to proceed?
No, kindly see, my Lord, last 10,
Proceed on merits or you want beyond that?
but if they consider, my Lord, they will hear me as a,
Since you are giving, since you are insisting for hearing at the back end of the vacation. The vacation is onset of the vacation.
not fine.
Do you
No,
want,
merits, my Lord, I cannot ask.
do you want hearing on merits? Then
No.
ready to, because you are
No.
bound to hear.
Lord, let
Or
them,
you want beyond vacation?
No.
Option is yours.
Lord, let them reconsider, my Lord, if you want to reconsider their option. Other,
You have to argue on merit.
no, then my Lord, give a short date, my Lord, any
You are
fixed date,
welcome to argue.
any fixed date, my Lord, immediately after vacation.
Pardon? Learned advocate, Mr. So and so. Request.
Let them file objections, my Lord.
I will do so.
Not-
Shortest possible dates after Dussehra holiday.
Please, please,
And over to 23rd October.
23rd October.
Grateful, my lords.
You file whatever in the
Let
meantime.
them file objections, my Lord.
In the meantime.
Madam, one more objection, my Lord, one more thing, my Lord, submission.
Objections.
These are all technical issues, my Lord.
Statement of objections shall be filed by learned counsel for the
Madam, yes.
Karnataka Pollution Control Board.
And one more submission, Lord. These are the appealable orders. Under the Air Act, my Lord, there are appealable. The government, my Lord, has not not government, all are, yes. Not appeal, no, appellate, kindly listen, I'll make one submission. Appellate authority is not,
Appealable order under which provision?
no, my Lord, section 31 of the Air Act. No, appellate authority is not there.
How many?
No,
Authority is not sitting.
not
my
there,
lords.
Lord, state government has to constitute authority, my Lord.
Yes, that is our job.
Not functioning.
No, my Lord. That's what, my Lord.
Direct the state government.
Please, my Lord, that is required, my Lord. Otherwise, my Lord, these are all technical issues, my Lord. I cannot trouble, my Lord. State government should constitute, my Lord.
Fairly stated by learned advocate of the petitioner that the order impugned in this petition, in the petition, common order in 6
But
months.
it is not functioning, authority is not there.
Is an appealable order under section 31 of the which act?
Air Act.
1A of the
Air
Air
Act. Full stop. He however submitted that the appellate authority is not constituted.
Not is from
And is
constituted.
not functional. Full stop. In that view, before the next day, from a learned additional government advocate.
Yes.
Modi Nilofar will take instructions about the time within which the appellate authority will be constituted. So we'll
Yes.
give little longer, stand
Yes.
over to 4th of November.
No, my Lord, that is not, my Lord. I will make submission. My Lord. My Lord, my Lord, my 7 industries are closed. My Lord. Let it be on 23rd, my Lord.
25th, 20th. You say,
If they constitute, my Lord, I will go there, my Lord. The
Okay.
technical issues involved, my Lord.
is right. Why it is not functioning?
Lord, I'll seek instruction and make that. Lord, a copy of this order, please, my lord, so that I can
The order
commit,
shall be made available by the registry to learned additional government advocate
apply.
to enable her to take instructions as.
Oblige. Oblige.
What is it?
No, in the meanwhile, my lord, I mean, permitted to complain of subjections, my lord. Not many of them sit there.
Before the next date, all office officers, as may be required, shall be complied.
List one, still number one, contempt matters.
My lords, I am appearing for complaint.
complied, my lords.
My lords.
It's
My lords,
complied.
on dated, as per dated 25/6/2024, direction or issued to consider my representation, my lords, regarding issuance of my rural certificate, my lords.
Complied with.
My lords, response are not issued
We have
till
issued.
now, my lord.
We have issued. Sorry, my lords, there's no translation.
Directions of the learned single judge brought under this contempt jurisdiction was to decide the representative petition. When the petition comes up for consideration today, learned additional government advocate promote the petition, produces copy of what is this?
Sir, rural candidate certificate.
Rural candidate
Rural
certificate.
candidate certificate.
Rural candidates are certificate, which marks the compliance of the direction. The factum of compliance could not be disputed by learned advocate Mr. So and so for the petitioner. In the above view, the proceedings are disposed of. Correct? Thank you very much.
Blessed.
Still number two,
Fee of the certificates.
Shivshankar Vaidi, two.
Lord, I appear for a complaint in this case. Next, I
Complaint.
read the direction issued by the Honorable Court. There are three, my lord, there are the directions by Honorable Court. Direct the respondent number 1 to 3 to conclude the inquiry conducted under section 64 of the Gram Swaraj and Panchayat Raj Act so far as alleged violation of the private respondent for putting up illegal constructions. But so far, my lord, the inquiry has not been completed.
What is not completed?
There is a clear directions to initiate.
Where is that?
No, para 3, your lordship may kindly see. If there were to be so, the matter does not call for further adjudication. Needless to say that as there is an interim order in the appeal pending as referred to above, the respondent number 1 to 3 is to conclude the inquiry under section 64 of the Gram Swaraj and Panchayat Act 1990 that is initiated so far as the
Inquiry-
alleged.
Inquiry is completed.
So far, they have not completed.
Who will appear?
Respondents,
No time limit.
no, the executive officer, Taluk Panchayat.
Full stop. The part of the directions contained in paragraph 3 of order of law and single judge dated 11/1/24 are complained of for their non-compliance. Full stop. Learned advocate for the petitioner so and so stated the inquiry has not been completed, though it was directed as above. Paragraph. The directions in paragraph 3 read as under. What paragraph? Page 11. And could be seen from the bare reading of the directions that for completion of the inquiry, no time limit is indicated by learned single judge. In absence of stipulation of time-bound completion of inquiry, it is not possible to take view at this stage that any of the respondents have committed a contempt, much less willful contempt of the directions of learned single judge. At the same time, the respondents cannot have a license to prolong the inquiry reasonably. In these circumstances, it is provided that the inquiry contemplated to be completed by learned single judge shall be completed by the respondents within a period of 3 months from today. Full stop. At a later stage, if need be, it will be open for the petitioner to invoke the contempt jurisdiction. If the inquiry is not completed within the contempt petition is accordingly disposed.
Number three, Mr. Jagdish Shastri.
I'm for the petitioner. Lord, the petition is working in the second responder institution. My lord, the second responder has now disturbed by passing the order on annexure C. The petition is already working, earlier is working, Lord, in the second responder institution. Now the court has passed the order, my lord, not to relieve the petitioners, my lord. But the second respondent, second accused has passed the order, my lord, Annexure C. In my place, my lord, another teachers are appointed, your worship. Therefore, I was seeking the relief, my lord, not to relieve the petitioners, my lord, by passing the.
Notice written on 4th November.
So PL matter, seal number 4, MS Chandrasekhar Babu.
This case I appear for.
What is PA?
Article 19(1)(a) of the Constitution of India, my lords. Right to expression, right to speech and expression is questioned, is requested for respondent number 1 and 2, my lords. This is a public interest litigation regarding conducting of National Day, my lords.
You're from British Empire,
Yes, my lords, my lords.
hailing from British Empire.
Yes, my lords. What had happened, the,
India declared general public red fort.
yes, my lord.
Slogan. What is red fort that got independence? Rest with the.
My lord,
destiny.
this is a matter wherein
There is a
we
trace
got,
with-
we got independence from the British, thing. They gave independence because of the reason that,
Independence was traced with the destiny.
yes,
It's traced with your destiny of your petition.
not that, my lord, what had happened because of the efforts of the Netaji Subhash Chandra Bose, they had gave independence, not the mercy of the other. Your lordship,
Commissioner Kamath is there to receive the result. Right.
It's clearly in the domain of policy.
yes, yes.
Clearly in the domain of policy, my lord, he shouldn't be coming here. Probably the only relief that your lordship can grant him is
Madam.
spare him from the costs. The only relief is
Alla. What, no, this is this is in the interest of general public, I have filed. Because what had happened during the year 1947, the British Empire has given independence. We take independence due to,
Which day you want? Independence? Day?
your lordship kind of look at para 2, my lords.
No, he is saying that exclude this independence.
he wants to move it to September 22nd and 23rd.
No, not that. So whatever whichever the,
Page 138,
that is there, one of the request.
There is Annexure H.
page 138.
Annexure H, my lords, 138, my lords.
Some 4 different holidays he wants.
That is, 134 is the first, this thing, my lords. 137 is for 4 national holidays, my lords. That's a different issue, my lords. My first prayer is to request for considering the case of the petitioner to to celebrate National Day instead of Independence Day, my lords. Is the question for consideration before respondent number 1 and 2, my lords. The Annexure G 134 is the first prayer, my lords. The second prayer is Mudera, your lordship kindly Annexure H refers to, my lords, Mudera temple in Ahmedabad, which is located in Gujarat, my lords. That is the central point for entire world, my lords. We are having scientific documents to substantiate, my lords. That is the reason we are before this honorable court to celebrate 4 national days, my lords. Annexure G is the, my lords.
The petitioner herein is an artist.
I am an advocate, but with your lordship kindly. Yes, thank you. Your lordship kindly, the first petitioner before this honorable court is a practicing advocate.
How many petitioners are there?
2 petitioners, my lords. First petitioner, I am a
Artist.
from
The
past,
petitioner is artist. Okay.
from past 29 years, I am practicing in the exclusive in the High Court.
Advocate.
Yes, my lords. And My father was also an advocate. My grandfather was also an advocate practicing in the High Court itself, my lords.
You are the petitioner.
I am the petitioner, my lords.
You are the petitioner.
I am the petitioner requesting this honorable court to writ of mandamus directing the respondents to consider the case of the petitioners
If you are the
in
petitioner,
respect of the annexure H and G. my
you are
lords.
the petitioner. Then
Yes,
we will
ma'am.
not say anything.
Well,
Otherwise, we were going to say something about the petitioners also.
You know, my lord,
We'll say that the first petitioner is
first petitioner is,
an advocate by profession.
please. My
Whereas,
submission will be taken. my lord.
whereas the second petitioner is an artist.
Addition.
Both are,
He's a
both
sculptor.
are good friends.
Yeah, both are we are.
Mr. Counsel, this petition cannot be entertained. That is the short and sweet
Well,
answer.
I mean, no.
First petitioner is advocate by profession, whereas the second petitioner is stated to be an artist by profession. Also, the petitioners have made, this petition is filed in this petition is filed invoking the jurisdiction of this court under Article 226 of the Constitution, styling it as public interest petition. Paragraph. The petitioners have stated, petitioners have made representation dated 9/8/24 to the Secretary, Union of India, Home Department. Full stop. The relevant part of the representation, which is a detailed one, deplete of variety of facts stated by the petitioner, comma, details in the bracketed portion 137. Our earth is 365 days in a year, moving in, no, not to write this.
Annex G, my lord.
Our earth is moving in 4 directions.
No, not that is in different, second, no, no, my lord, your lordship kindly appreciate, my lord, sir. Modera in Gujarat, my lord, sir. That is the central point for all. We are having scientific documents.
You
to
are
prove.
making us move in the 5th direction.
Yes, my lord. No, yeah, because if.
What kind of petition?
Only requesting, my lord, sir.
What?
Please, I leave it to your lordship.
Don't leave. It will entail heavy cost.
I'm sorry.
What do you prefer?
I will withdraw, my lord, sir.
Withdrawing. Learned advocate 6 permission to withdraw the petition, dismiss the withdrawal.
Much obliged.
Withdraw this public interest, please. Dismissed as with. Yes, next.
Green bench matters, cell number 5, Mr. Chidanandaras.
I'm appearing for the petition.
Yes,
Your
Mr.
lordship.
What is it?
Lordship, the facts are, your lordship, that section 9B, your lordship, was inserted under the MMDR Act, your lordship. Section 9B was inserted under the MMDR Act, your lordship, from 12/1/2015 for constitution of what is known as District Mineral Fund, your lordship. This is the concept of polluters pay. Whenever there is a mining activity undertaken, section 9B was inserted by the central government. Your lordship, that section stated, your lordship, what is the purpose of the funds which was to be given by all the mine owners to the district, because it had to be used.
We will keep it on 21st of October. No urgency. Next. 6.
Your lordship, the difficulty, your lordship, is that the district mineral fund, there was a district which was carved out.
None of your right is infringed. What is the right immediately infringed?
Your lordship, the difficulty is that when the funds is collected, I have already paid 485 crores to the new district, your lordship.
General things can be dealt with later. Yes.
Because the money is not available from the district mineral fund of Bellary, and they're insisting that after the state is constituted.
We are not discussing it. 21st of October. Yes.
Oblige, your lord.
Number 6.
No. Lords, this is the matter on lakes in which, my lords, on the
Not
previous date.
Not now, after vacation. It will go to 4th of September, 4th of November.
My lords, could it be in October sometime, 21st, 22nd October?
28th October.
28th.
One submission.
as dealt by this court in earlier matter, let them go on with the removal of enforcement policies.
In fact, my lord, that is coming in the way, my lord.
Directions are there, gone
28
back in
is out.
2019. Let them go on with that. at
Can I
least.
make one
Because there are
suggestion? my lord?
several places which are given and given to my learned friend. Identified which are the places, the removal of enforcement. They are not done till date. Partial report has been filed.
So they are coming
So
out.
let
with
them
some
go ahead
policy.
with the.
In fact, we have placed the policy before your lordships, my lord. We have served a copy on my learned friends also.
We have our responses. We'll give our responses.
Right.
Can I request my learned friends to give the response? If it can be rectified, we will we'll include that response, my lord.
I'll do that before 28th. I will.
Give in writing so that we
Yes.
can
So that-
also,
Yes.
we
I'll-
can also the benefit of
If
it.
you have to
Yes.
change it, my lords, we'll incorporate the change and give a fresh thing. Otherwise,
I'll-
my lords, we'll give a reply, my lord.
It is a matter of time that we'll deal with.
Yes.
We'll deal with it. Only thing that we have to apply the mind by passing.
I understand, my
Yes,
lord,
yes.
because I understand.
Yes. 28th.
Seal number 7.
Hearing for the respondents.
Three o'clock.
Please, very good.
Please.
So writ appeal matters, seal number 8.
Appear for appellant. It may be taken up after vacation.
Pardon?
It may be taken up after vacation.
After vacation. Thirtieth October.
Seal number 9.
I appear for the appellant, my lord.
Delay. Notice returnable on 30th October.
Number
10 also delay.
10. Manmohan PM.
30th October. Notice returnable.
Yes, very well.
Seal number 11.
But serial number 11 also, my lord, it is connected with 9, may kindly be taken up on 30th of October.
11 stand out to 30th October to be
Obliged.
taken up along with writ appeal number 974 of 20. Yes, in this also 11 also notice returnable on 30th to be listed with writ appeal number 970.
Seal number 12.
Not for the, that is for the appellants, 12 and 13 are all connected matters. Your lordships took it from day before yesterday to today. Matter relates to selection, provisional select list is now issued.
Provisional selection to
The Karnataka Power Corporation Limited, without reference to papers, the issue is this. They issued a recruitment notification for various posts. The recruitment notification, did not speak about negative marking. Neither did the cadre and recruitment rules,
6th November.
Now, if they publish the final seniority list, some semblance of right will be created in third parties. Our prayer is only this: let the selection process go on. We don't want to interject in the selection process ultimately. Now, let them not create third party rights. The reason is only this.
I'll make my submission after.
Just the reason is
On 16th we'll take up, 16th of October.
6th, great.
till then if they don't publish the select list.
My lords, no, my
If
lords,
they-
interim order was in fact refused, my lords. My lords, what has happened is insofar as the petitioners, my lords are adjourning it. I'm sorry, my lords. I'm
On
sorry.
that day we'll apply.
Yes, sorry.
Yes.
Till then, Right, if they issue the final select list, my
We'll
petition,
set aside the list. If it.
right, I'll have to challenge it.
If
I'll
you
have to
succeed,
trouble
we'll
your
set it.
lordships with another writ appeal.
But without applying mine, we will not pass any.
So lordship say at least appointment orders not be issued.
Not to issue appointment orders. In 15 days, I'm certain, my lords, they will not issue appointment.
My lords, I have my assurance. I checked with the client. In fact, they have also filed one more in Kalburgi. I have made a submission. I have made a,
Very well.
my lords, the problem in recording, my lords, is that then they will, my lords, I have my assurance.
No.
My lords, till 16th of October, definitely, my lords, till about 20th of October, my
They are
lords.
recording our ears.
My lords, I have my
Very well.
assurance.
Very well.
Ajay, is it?
15th October.
When do you want?
My lords, can it be on 16th, 15th, my lords, the Kalburgi matter is that they have
16th.
challenged the same thing.
Very
Another
well.
set of people have challenged the same thing in Kalburgi.
Great.
My lord, 87 is also, my lord, the same issue, my lord, against the same judgment. That may be connected, my lord, along with this petition. Serial number 87, writ appeal.
87. In 87, my lords, sir's name is now.
It is a notice to, notice written. Same date, 16. Learned Advocate Mr. N. K. Ramesh accepts notice on behalf. This one number. What? This one so and so. This one KE.
So it's number 14. HV Devraj.
I appear for the appellant in this case. There is a delay application.
Notice written on 21st November.
Much obliged.
Say number 15.
15 is a government appeal, my lord. There is a delay of 169 days.
Notice returnable on
Please, it-
23rd November.
a shorter date.
26th November.
My lord, we've asked for a stay of the learned single judge's order anytime after the vacation, my lord,
This is after
as in October,
October, 29th, 28th October.
please.
Say number 16. TP Muttana.
Yes,
I'm appearing for respondent, my lord. Matter pertains to promotion.
it can wait.
Please.
5th of November.
17, 18 are urgent. Still number 19.
That's contempt, wherein on the last date, my lord, this is for teachers, for special educators, my lords, recollect.
We have
my
filed the
lords,
affidavit, my lords.
And I have also filed a reply to that affidavit. My lords may just see the last order on 12/8. My lords had in fact passed an order on the last date saying that, stating that it was stated by learned additional government advocate Srimati so-and-so that copies of certification are given to her and the authority shall be instructed in light of the same to examine whether petitioners possess the requisite qualification of Rehabilitation Council of India and necessary steps thereafter shall be taken to give the appointment if they are found to be
Which-
possessing.
Which order?
Sorry.
12th August?
12th August, sorry.
Lords, we have redone the
1 minute,
exercise.
1 minute. And if they are found to be possessing the RCI requirement in accordance with law, they will give the appointment. And then we undertook to submit those letters. We submitted the letters. Thereafter, the government has filed an affidavit saying that despite getting those certificates, you are not eligible. And I have filed a rejoinder. My lords, in my rejoinder, in fact, to 3 of them, they gave me appointment. On 3/9, that is 3rd September, after I submitted my certificates, kindly if my lords may
I
see.
do not have their rejoinder, my lords, copy of their rejoinder, but I will submit on the affidavit
My
that I
lords,
have
they were
filed.
served. They were served. I will just give one more copy. In fact, it has been served on them. If my rejoinder can be seen, which was filed, my lords, yesterday, they have in fact given for 3 of us appointment. And after giving 3 of us appointment, they have orally told us not to come. And my lords, all of us have the same identical certificates. And our appointment orders I have produced. My lords may just see my rejoinder filed yesterday, my lords, 26/9. So now, my lords, for them to say that you don't have the qualifications after appointing me, 3 people have been appointed, my lords may just see my appointment, my rejoinder on 26/9. And in 26/9 rejoinder, my lords may see page 23.
But you go through the reply.
Yes,
My lords, I'll go through, my lords. My affidavit, my lords, we have strictly followed the Supreme Court directions, what the educational qualifications are required. And we've also returned to the MO.
It is filed.
It is filed, my lords, on 13 September. The entire exercise has been redone. I've produced even the Supreme Court judgment, my lords, which is at page 6 of the affidavit filed on 13 September 2024.
If that is the case, my lords, how they can give the appointment to 3 of us?
That I'll verify, my lords.
How they can give to 3 of us? On one hand, in their affidavit, they say they are not eligible.
26/9.
13 September, ma'am.
No, no. They filed an additional affidavit dated 10/9. And thereafter, I filed my rejoinder yesterday, giving the appointment letters for 3 and not to the
My
others.
lords, to reply that we have given, we have rejected them based on the educational qualification, my lords. I have that order here. So we have not given anybody who do not qualify, my lords.
My lords may just see for a moment.
Let it be after,
Please.
on 21st.
21st.
Number 20.
Appear for
Ramesh
complaint
KR.
in this matter, my lord. Non-compliance with the order possible by single judge of reasonable court. My lord, I filed a contempt petition. They have filed a complaints affidavit, but they have not served the copy. My lord, they have served the copy. I will gone through that. My lord, I will kindly have it next week in this matter.
Complied with.
My lord, I will gone through the records.
Filing what? Compliance of it.
My lord, one request. My lord.
Send over to 16th October at
Okay.
2:30.
Problem.
Take instruction.
Please, my lord.
Number 21.
Anyone, I appear for the petitioners.
Pages is
Petitioners are associations representing around 2,000 residents of Indiranagar in Bangalore. They have filed this PIL seeking directions to the state government, the police and the various authorities to take steps against establishments violating various laws, including excise laws, noise rules, and so on and so forth. It may be taken up after vacation. My only one request is this honorable court earlier had passed directions to the police to conduct surprise inspections and measure the noise levels by various establishments. That is not being complied with. May I request that be adhered to, and it may be taken up after vacation. I will make my detailed submissions in the matter.
In fact, the petitioner.
24/7/19, 38/19, and 19/9/19. There were 3 orders.
24/10, sir, next. 24/10.
Please,
fact,
just
my-
request the police to conduct the surprise inspections as per the earlier order of this court. This court had, may I request the honorable court kindly look at 19/9/19.
In
The
fact,
court
my
had said
lord, the
until further orders, the
and-
surprise inspections to be
No
conducted.
order, no modification without replying, man. Yes, next.
No modification, lordship. I'm just asking for implementation of the earlier order of this court. This court had said until further orders.
Yes,
they will
I'll
conduct.
look into that. In fact, my lord, the petitioner was supposed to file a status report based on the reports filed by the state. And also respondent 4, which is the Association of Residents, were also supposed to file a status report.
That has already been filed.
We haven't got a
We have given
copy.
copies.
didn't
I'll
know.
serve one more copy because with
Serve
acknowledgement
us
we have
the
filed it.
copy, so accordingly,
We are not received.
we haven't got a copy, so serve us
I'll
the
serve
copy.
because with the acknowledgement we filed it.
Next.
Number 22. The Maitreyi Krishnan.
No matter
My lord, this matter,
after vacation.
my lord, only one submission, my lord. On the last occasion, the state has had a state committee meeting, my lord, in respect of the issues pertaining to manual scavengers, where several decisions have been taken. if they could just place on record the steps taken thereafter, my lord, then we would be able to respond to the same.
Level please.
Minutes of the meeting.
Stand over to
After 8 weeks, my lords, after
Yep.
8 weeks, I did.
6th September, before the next date. The details about the developments which may be taken, which developments which may have taken place at the end of the respondents shall be placed on them.
Please, great.
Grateful.
We'll assemble at 3 o'clock, 3:15. In the second half, 3 or 3:15.
29th, I'll seek a short accommodation.
77.
Submission is in accordance with the rule 14(2), and the accept my submission and post it for preliminary hearing.
Pardon?
Post it for preliminary hearing. Kindly accept my submission and post it for preliminary hearing.
77. Some of
16, rule 14(2), I have noted, my lord. They have to, your article has to accept it.
So what is it about?
This-
What is the subject matter?
The subject matter is in spite of a demolition order passed by the Karnataka Municipal Corporation.
Hmm.
The report number 9 is continuing to the illegal construction, even today.
22nd October.
Preliminary hearing. But
Item number 35, my lord. For the last few months, the matter is not reaching, item number 35, my lord. For the last few months, the matter is not reaching, there is some seriousness and urgency is there, my lord.
Not reaching.
Lord, in the last adjournment, 29/5/2024, I submitted that the 13th respondent grabbed the public road, elementary school and the public borewell, my lord. After that, after receiving this honorable notice to this 13th respondent, he high-handedly converted the elementary school into the house, my lord. I am here with submitting some important photos and document, official given documents regarding the school and other issues. Kindly allow me to submit that. One zero five. School and 105, the school and photos are and 101, the road is mentioned. Page number 101 and 105. The elementary school and the borewell is mentioned. Now the 13th respondent is converting the elementary school into his residential house. That is also after receiving the notice, my lord. When matter is pending before the honorable court, the lawless 13th respondent is converting the public elementary school, small school. The surprising point is the 13th respondent himself studied up to 4th class in that school, elementary school. My lord.
So
Kindly see the photos and important documents issued by the Panchayat government officer regarding school and other.
So you want to use the road or block the road?
Huh?
You want to use the road or you want to block the road?
The public, we want to use the road, my lord, but the 13th respondent is blocked part of the road.
Who has blocked?
13th respondent, G. Suresh.
13th respondent.
13th respondent. The some other important point is.
One second. Who is 13th respondent?
G. Suresh.
Private party.
Yes.
Lord.
Private party. Private party.
And who has filed the civil suit?
The 13th respondent himself filed to block the road and to harass the public. He utilized the local trial court as a platform. He filed 2 suits with 2 different father names.
Who has filed?
13th respondent.
Huh?
Right?
Then you go there and make an application.
One submission.
Go in the,
road
go in
is-
the pending suit and file application for him becoming part.
Then all the things will add, once the road is blocked, the lifeline rights are, the public are suffering.
We'll reserve you for.
Milord,
Well, I appear for the
I have-
13th,
for the last
14th and
7
15th respondent.
Some order must have been passed in the civil suit.
Yes.
No, because once the road is blocked, the public fundamental rights are destroyed, Milord.
Once suit is
Not
pending.
Once, total village, 4,000 villages, public fundamental rights are blocked.
So what is
And
what is the relief in the, your suit?
My lord, the relief, my lord, is a permanent injunction. We have obtained, my lord, the interim order, but not to interfere with the peaceful possession of the property. So it is not a public road. So it's a
You are claiming a private.
private property. It is my property. Two suits are pending. Two suits are pending. My lord, in one suit, my lord, so they filed, my lord, an application under application IA number 6 to seek relief under Easementary Act. My lord, that application is dismissed.
What do you say, madam?
My lord, two suits are filed, my lord, and because of the injunction order, my lord,
Suit is 201 and 369.
Yes, my lord.
yes,
Two
yes,
suits are
my
pending.
lord.
Two different father
So
names.
that's
Both are
that's a
filed by
different
you.
issue, my lord.
Two different father names he filed.
Both are filed by you.
Yes, my lord, I have filed.
But
But
respondent.
but the 13th and my lord, 14th.
369 is, where is that? Is plaintiff ready?
A plaint is at page 115, my lord. Page 115 is the plaint. It's filed by,
115 is,
So there the prayer is, what is the prayer?
1 minute.
Permanent injunction.
prayer, my lord, which is
Independent
at page
judges.
number 116.
G. Suresh, son of Gangappa, one suit is filed. G.
So this is
Suresh,
the-
son of Gangadharappa.
Very road,
My lord.
same road. The relief of permanent injunction is in respect of the same road.
Now, in respect of, my lord, two scheduled properties.
Same road which is,
No, same, it's not a road, my lord, we are claiming. My lord,
same road which is subject and paid subject matter of this PIL.
yes, my lord, they
The
claim,
same land.
same land,
Same
same land, same
And
land.
which is the other suit?
Other suit, my lord, is, my lord, OS number 201 of 2022.
156, page number 156, see the 156, Mila, page number 156. In that, he used, he mentioned his father name is Gangadharappa. That is, Aadhaar card is tampered, Mila.
One,
My lord, page number, OS 201.
156. 23, 156.
so that is by same person, no?
No,
G. Suresh, same person.
G Suresh and one Nagesh.
Both.
One Nagesh, that is the respondent number 15. Now, that is in respect
But
of, my
G.
lord.
Suresh is filed two different father names. Kindly see, the, in 115 page number, he mentioned his father name is B.N. Gangappa. In
But why you are,
156,
Lord, the
Gangadharappa.
properties, my lord,
why you are filed suit, two suits?
two suits, my lord, one suit in respect of two items. In another suit in respect of 95/1. In first suit, my lord, in respect of 94/2A and 2E, with respect to 1 acre 24 guntas, and another survey number 95/12,
This
with respect to
90
30 guntas.
This is 95/1. It's
Ah,
other suit.
Yes, my lord, the first 369 in respect of 94/2A, 2A, 2E.
90,
4/2A, 2E.
where is that? 94,
Bar 2A, 2E, page 117, you lost me, kindly see the schedule.
94/12.
And second item, my lord, 95/12 measuring 30 guntas.
Here my submission is
Wait, sir.
161. Kindly see the 161 page. Mila.
My lord, suit
Page
no,
number 163. Kindly see the 163
Subject
page
matter.
number. In this, he mentioned, he given verifying the affidavit, G. Suresh, son of Gangadharappa. At the same time, 122, first suit, 122, page number, see the 122, Mira. 122, why? Because he played fraud on the court, Mira. 122, page number. In the verifying affidavit, the same very G. Suresh given his name, 122, his name is given as Gangappa. The advocate also identified with the two fathers' name. In the verifying affidavits, the very same advocate identified as Gangappa and another suit Gangadharappa. The notary also same.
So we'll,
Finally, two fake suits. Moreover, first suit is filed, kindly see, my lord. First suit is filed,
So,
11/9/9.
Two suits are pending.
when two suits are pending
Interim order is granted.
and the same land is involved,
Plus, my lord.
About which?
Part of the public road, part of the public road. Kindly see page number.
you go there and point out to the learned civil.
Please, my lord.
One minute, humble submission there. Please see, 101, 101, kindly see, 10, after that, the humble court may pass any others, 101. 101. The Google map, my lord, as per MC Mehta versus Union of India, the Honorable Supreme Court stated that the Google Maps and drone shots are utilized for eviction of the unauthorized public lands, my lord. In this, the suit, the Google map is 5/1/2018. And at the same time, 154, my lord, kindly see.
How can you use the road? You block the road, public road.
No one blocks the road.
How can you do? How can?
101, there is
No, it's not a block.
No, we'll have to examine it.
Right.
How can you do? Correct. So you want to give submissions, written submissions?
Yes, I already filed, my
Right,
lord.
where is that? We can't block a road according to you.
According to me, he blocked the part of the road and two suits filed as weapons to curtail the fundamental rights of the public.
It's pending. It's pending before the civil court. It's my property.
No,
It's
civil
my-
court is nothing against PIL. This is PIL.
Yes.
For the last,
You have filed your submission.
he can say,
Where is your submission?
yeah,
Where is your submissions? Written submissions are filed?
yes, sir, the written submission is filed. In the bill, my written submission is, prayer is filed, my lord. Prayer also filed in the bill, the main prayer is.
Main
the-
petition is filed.
Lord,
Main petition is filed.
petition is filed.
And in that prayer is there.
Yes, prayer.
Where
there,
is that prayer?
49.
Page?
Page number 49. Kindly, before going to that, kindly see 153, page, before going to that, kindly see
No,
153. Kindly see 1 minute, my lord. 153, page number 153. Before going to that, kindly see 153. Drone shot is there, my lord. The road is clearly appearing.
130,
153,
150.
153.
Map, Google map?
No, it is a drone
Ah.
shot.
No, Google map.
So next to 154 is the Google map.
Acha, this photograph.
This photograph is drone shot map. The two villages road is clearly appearing and the date is next to 154 Google map, dated is 12/12/20. The suit is filed, first suit is 11/9/2019. Before that itself, 101, 5/1/18 itself. Apart to that, kindly see 103, my lord. Kindly see 103, page number 103. My humble submission, my lord.
He says that crops is grown, fully grown up crops are there.
He says that before that Google Maps, everything, it is a false statement, my lord. Google Map itself proves, prima facie, the face of the Google Map itself shows, the road is clearly, drone shot itself clearly. And another, before going to that, please.
Oh, my lord, I have filed the wakalat.
Okay.
My lord, my name is also not shown. I filed my detailed statement of objections.
Another
Filed in
important
the
point.
2 weeks time, my lord.
Another most important point, my lord. 103. And 50 lakhs is granted to this public road, my lord. 149, Karnataka government itself granted, if the road is not there, how the Karnataka government granted? 149. Page number 149, 50 lakhs is granted for this road.
You are dependent?
Miller? Page number 149, Miller.
You are dependent in this suit? You are dependent in this suit? You are dependent in this suit?
I and the defendant as
Ah,
well.
that is the point.
Yes, I mean, when my fundamental rights is, when my fundamental rights are, all the defendants are, my lord, 1 minute, my lord. Defendants are the.
I have not, I have not, I have not practiced in the trial court, but I know how to cross-examine.
No, when they, and one thing, when the fundamental rights are, curtailed, the Honorable High Court has constitutional.
So
court
this
has to be-
raises a very serious issue. Very serious issue you are raising.
My lord,
Fundamental right to use road of somebody else.
My lord, the fundamental rights, the public, for the sake of one person, he utilized the court, he utilized the suit.
Very
weapons, my lord.
Very serious issue. You have filed reply and you don't want to file reply.
No, no, just now I filed the wakalat. My name is also not
So
sure.
we'll examine it. Reserved for judgment.
Until then, my lord,
No, no, until reserved for judgment. Until what?
my humble submission, kindly see, page number 149.
But we have heard, now this is a
149.
bulky record. Yeah.
Last
What one?
Last
You-
point, 149 page number,
So we'll examine. This is very important issue you were telling.
149,
149.
please,
What is it, 149?
149.
Google map,
50 lakhs is government, government sanctioned 50 lakhs for this road, my lord.
Hmm?
50 lakhs government sanctioned this road.
150,
149.
140. 149 is in this Kannada.
Kannada, English, 151 is in English language.
What is
Second
it?
item, for the development of this Balakunta, Vikalahalli and Balakuntahalli, 50 lakhs is sanctioned by the government. And 103, Panchayat Development Officer is given this certificate that 2017 itself road is formed. 103, my lord. That is also kindly perused, 103. 103, my lord. This is my humble request, my lord.
So we are seeing every page you want.
Please, my lord. This is.
We are
for
seeing
sake of
every-
public, my lord. I stood for good cause, my lord. 103,
103, yes,
103.
103.
In this, the 2000, the PDO issued certificate in 8/12/2017. The road is developed by the NSU students, my lord. NSU students have developed the road. NSU students have developed the road. And kindly take this written submission, my lord. Written submission.
Written submissions are bigger than the petition.
This, the photos are mentioned, my lord. Photos are mentioned, my lord. Kindly page number 7, my lord.
Yes, page number 7. These are,
Page number 7 in written submission.
but you are friend of the defendants.
My lord.
You are friend of the defendants in this suit.
Both the suits, they are the defendants.
Defendants are the GAP.
If we started asking you, then difficult, you will be in difficulty. Are you friend of the defendants in this suit?
I am appealing for Gram Panchayat president, sir.
There. In the civil suit, there are private defendants. Private parties are defendants,
Private party along with Panchayat Sarkar.
all along with Panchayat. But we are just asking
Two
that,
Panchayat presidents are the defendants, my lord.
we are just asking that, are you friend of those private defendants? You know those private defendants?
We are fighting as defendants in that suits, my lord.
Ah, you are fighting, whether you,
But once the road is blocked by
Your
the
latest-
interim order,
your name is there in the, as a defendant? Your name is there in the suit, as defendant?
Yes, is there, my lord.
I am appealing for the sake of, as
Plain-
an advocate, I am appealing.
Petition number 1.
So this is D6 in?
And you page number 7 and 8, kindly see the page number 7 and 8, Milad, in the written submission.
Now riddle is solved.
Milad, kindly see the Milad, kindly 1 minute, Milad.
We are hearing you, sir. We'll examine everything.
The road is clear, mentioned, paved by the students, Milad.
But we are reserving the judgment. Heard learned advocate Mr. So-and-so, so-and-so. For the petitioner, learned additional government advocate. Srimati Nilofar Akbar for respondent state and its authorities.
Respondent number 8. Respondent number 8.
Learned number so-and-so, so respondent 8.
13 to 15, Mohan Kumar.
Learned so-and-so,
8
13.
Devraj.
10. At length. At length.
I further.
No, further length not necessary.
Honorable court permit me, I find in the written submission, Aadhaar card also.
So we are saying heard at length. Heard at length. Reserved for judge.
Milord, I appear for respondents 1 to 7, 9 and 10.
1 to 7,
1 to
9
7,
and 10.
9 and 10.
Respondent 8. and objection.
Thank you very much. Now don't complain that matter did not reach.
Well, what the Honorable Justice Gavi observed that
Lie, kya hai? Let us see.
when the fundamental, when the judiciary in India has repeatedly demonstrated that our constitutional courts cannot sit with folded hands, when the executive fails to perform its duties to land our privileges.
You pass it over. Whatever important you are reading, you pass it. Only one copy? No, we'll share the. Tomorrow. There you. Very good.
And another mission, Honorable Chief Justice also stated that knowing the people's problem, better for lawyers and judges to give good judgment. The second respondent, 2 suits utilized as a weapons to curtail the public's fundamental rights.
Very well. So shall we keep this on record or you'll?
Please keep it in the record. I will submit.
Supply sec.
And written submission, I also added, submitted judgments also submitted.
We'll consider.
Please.
Next.
Case number 3 for pronouncement of judgment in serial number 1 RP 138 of 2017.
So 138, 138. So review petition is dismissed.
Serial number 2 writ petition 25,219 of 23.
Petition is allowed. Petitioner shall be treated as duly admitted to MBBS course. University shall treat him as admitted, duly admitted. And he shall be entitled to complete the MBBS course. Now your result is declared?
Result is not declared.
First MBBS not declared. So there is a direction to declare the result. The result of those subjects are declared, anatomy and biochemistry. That is declared. How?
By virtue of interim order dated method, by virtue of interim order of this court method, the student has taken the examination method.
But then court said that.
Except biochemistry examination was not taken by that. That
But
exam result.
But result was not to declare. That is the order. Are you sure it is declared?
Early, my lord, anatomy and physiology examination papers results were declared, my lord. Biochemistry results were not, is not declared.
Sure.
Please,
Then we'll not say anything.
please, my lord.
Only MBBS result may be declared.
Please, my lord.
Yes.
List number 1, seal number 7.
Correspondent.
I've taken leave of this honorable court in the morning. I will wait. I will.
Sachin BS,
Yes.
seal number 7.
Yes. Respond 1 and 2. 7.
Yes.
Right. Correct.
The town municipal council Mudbidri is permitted to file fresh application as per the provisions of 1958, Act of 1958, seeking NOC within 3 weeks from today. Respondent number 6 shall consider the application filed by the city municipal council under section 20C of the Act of 1958. Respondent number 6 shall also consider the application to issue NOC within 3 months thereafter on its own merits. And in the light of the observations made above, the parties shall maintain status quo on construction activity till consideration of application by respondent number 6, subject to the extent of relief granted herein. Writ petition 31676 of 17 and writ petition 51844 of 2019 are disposed of. Writ petition 4829 of 2018 involving legality of the tender process shall be considered subject to outcome of the above directions. It is ordered to be delinked.
Seal number 46.
For the complainant, man.
46, what is the urgency?
But I made my effort on last date of hearing with respect to the, my lord, the connection of sewage to the, my lord, canteen. Your lordship may kindly peruse the, my lord, order of this honorable court, wide order dated 5th June 2024, wherein, my lord, this honorable court.
This is that you mentioned this.
Yes, please, man. Grateful, man. My lord, this honorable court has, my lord, learned single judge, my lord, at paragraph number 7, wherein, my lord, clearly stated that, my lord, sewage connection I am entitled, since, my lord, one of the, my lord, party has filed, my lord, suit, so that is, my lord, I am entitled to file the, I am entitled to get the sewage connection which was disconnected because it was connected in the year, my lord, 2011 itself, as per the statement made by the municipality before the court. From paragraph number 7, my lord.
Is not complied.
Not complied. And, my lord, one they have gave after the judgment of this honorable court with after the judgment of this honorable court by the learned single judge, my lord, with representation, I have made a letter to them. They have given one endorsement, my lord.
Who is for municipal?
I have filed the detailed application, date of the filing, till the filing of the affidavit. I have complied with the thing, because this drainage passes through the private property and it was completed. Thereafter, the land belongs to the temple. Temple people have removed it and the same complaint.
Sorry, my lord. Sorry, my lord.
It has been removed. So last time when the submission was made, then my learned friend said the temple has no objection. In fact, temple has filed an appeal against this order and
my learned friend who was appearing for that, he was in that, so I called him and he is here also. And there are two appeals, one is filed by me, because the direction was to trespass through a private property. and lay the pipes.
You filed appeal? You filed appeal against this order?
Two appeal, I have filed appeal in WA 1031 of 24 and
Lord, they have filed a review. It has dismissed. They have filed a review against the learned single judge order.
You have filed an appeal.
That 2 months back they have filed. Not even, my lord, remove the office objection till today. Because of their laying the writ appeal, my lord, I can't stop my lord, my canteen. I'm very sorry, my lord. Because of their, my lord, writ appeal, I can't stop my canteen. Because, my lord, they have totally, my lord, I have filed, my lord, before this honorable court with respect to the, my lord, running a small canteen after my graduation as a girl under the concept of woman empowerment by the, my lord, central government concept. Bharat Canteen I have been established in the private land. A person, my lord, who is not a customer, he is, my lord, leaseholder of the particular area, has observed by the learned single judge of this honorable court. Your lordship may kindly peruse, my lord.
Private land is a temple land.
No, my lord, temple is not before this honorable court. Temple is not before this honorable court. Person who he is in the, my lord, leaseholder of the collection of rent in the car parking area. Who has came before the court? And, my lord, it is not passing the, my lord, private land. It is, my lord, in between the land, my lord, there is a drainage. One single pipe, my lord, 2.5 HP pipe, PVC pipe is crossing the manhole, my lord. That is what the observation. Anyhow, my lord, that is no question of merits. Merits already decided. I am before this honorable court on contempt.
Filed your objections here
My lord.
in this contempt.
Yes, ma'am.
Along with the documents and photos.
My lord, in the first stretch, my lord, he has stated that, my lord. No, I will complete. I will complete. In the first stretch, my lord, he has stated that it is impossible to comply. He has made, my lord, this submission before the court number 2 as well as this honorable court. Then this honorable court requested them to file the necessary affidavit. Now they have stated that, my lord, we complied already. Now he is again stated that it is impossible to comply. What is their stand, my lord, ultimately? Their stand has to be, my lord, single. Either they have complied or not complied. They have stated before this honorable court, my lord, right now he has stated it is impossible to comply. Then, my lord, in the affidavit, he has stated that it is complied. Your lordship may kindly see the reply, my lord. I may permitted to read reply.
By order dated 5th June 2024, learned single judge directed the commissioner Udupi City Municipality to reconnect the sewerage line to the premises of the petitioner complainant within stipulated time. Civil suit is also pending.
Civil, yes, my lord. My lord, civil suit, my lord, the learned trial court has made a specific, the learned single judge has made a specific observation, my lord, wherein the municipality has taken the contention. They have issued the license, my lord, in the year 2011 itself. From 2011, my lord, it is operating. Your lordship may kindly come to the paragraph number 7 of the judgment, my lord.
By filing the present contempt petition, the non-compliance of the above direction is alleged. Full stop. Respondent municipality has filed affidavit cum reply, mainly stating 2 aspects which learned advocate for the respondent municipality submitted in course of the hearing. Firstly, that the drainage line, which is to be connected to the premises of the complainant, passes through a private land.
Private land belonging to a factory.
The private land belongs to a temple. It was stated, secondly, that the temple has filed. You have filed? You have filed?
Yes, I filed my writ appeal is my post on 4th/11 November 959/24.
959.
WA 959/24. Posted on 4th November.
Filed leave to appeal. My appeal is. It is yours leave to appeal. Leave to appeal.
And I am for the temple. I am for the temple. I am a party to the writ petition. I'm a party to the writ petition, my private property, my lord, and my appeal is pending.
Temple Authority, which was party
My lord, one
to the
submission.
party in the writ petition, has filed
My lord, one submission, my lord.
writ appeal number 959/24.
Temple never, my lord, approached this honorable court.
Not only that paragraph, it was undisputedly stated that the respondent municipality has also filed its writ appeal number
1031, 1031.
1031.
31 of 2024.
1031, 2024. In view of the above, it would be appropriate that this contempt proceedings is heard at the earliest, along with the writ appeals, since the order under contempt is subject matter of challenge in the writ appeal. Accordingly, both the writ appeals and the present contempt petition shall be posted. Admission hearing.
411.
My lord, till 411, it is impossible. At least, my lord, I may permitted to run, my lord, canteen in Dasara. After 6 months, I can reopen my canteen. In Dasara, my lord, has a girl, as a young girl, my lord, tender age. She has opened, my lord, canteen under the name and style of Bharat Canteen, under the concept of women empowerment, my lord, which has been central government scheme. I have, my lord, established at the age of 24 years, after completion of my lord degree. My lord, I'm running my canteen from last 4 years. There is no problem. After that, my lord, this municipality and my lord, private person who is a leaseholder of car parking area, he is, my lord, started to trouble me. After that, my lord, they have cancelled the, my lord, license. Then I succeeded before this honorable court. Then they have issued the license. Then, my lord, garbage. Yes, again, I succeeded before this honorable court. I succeeded. Then, my lord, they have filed one more case. That is, my lord, saying that you have put the trust sheet on the roof of the building. Again, I succeeded before this honorable court. Total 7 rounds of litigation I have succeeded, my lord. Here, my lord, in last case, my lord, wherein this honorable court specifically directed them to, my lord, give the sewage connection, my lord, which is in the drainage, which is in the pipe, my lord, the pipeline is, my lord, which is existing in the drainage, not either in the private land or, my lord, in the any other person land. Once it is a, my lord, drainage is, all drainages belong from the, my lord, it is a municipality. It is, my lord, as per section 221 of the, my lord, Municipal Corporation Act. All drainage is belong from the, my lord, municipality. Your lordship may kindly permit to read, my lord. May I read, my lord? 221, my lord. Vesting of sewers, etc. All public sewers, all sewers in, alongside, or under any public street within the city, and all sewage disposal works, whether constructed out of the corporation fund or otherwise, and all works, materials and things apprehending thereto shall vest in the municipality. This is the law. This is the law. All, my lord, street, manholes, drainage, public, the street lights, all belong, my lord. It is vest with the, my lord, municipality itself. It is not by the anyone. If my pipeline is, my lord, crossing the any private parties, my lord, of course. Even, my lord, municipality have right, my lord, to acquire the, for the purpose of existing the, for putting the pipe. Pipe is, my lord, only this much, my lord. This is 2.5 inch pipe, PVC pipe, my lord. Your lordship may kindly see the, my lord, photograph of the pipes. This is the pipe, my lord. This is the pipes. This is my building. It is, my lord, crossing in the drainage. This drainage to the manhole. This is the only subject matter, my lord. That is what, my lord, a PW engineer was appointed before the learned single judge with the help of the, my lord, police inspector of town, the Udupi city. All are, my lord, present at the time of, my lord, removing this pipeline. It was existing from 2011. It has been admitted by the municipality before the civil court, and this honorable court learned single judge has make out the point, and, my lord, made an observation that it is existing from 2011 itself. Your lordship may kindly come back to the, my lord, for a moment. Paragraph number 7, my lord. Wherein, my lord, this pipe, my lord, it is inside the drainage, my lord. It is inside the drainage. This drainage is not belong from anyone. If I am crossing this land, my lord, of course. This is, my lord, the only, here, my lord, it was there. They have forcibly removed, and, my lord, they damaged the compound wall. For the pipeline, my lord, I am before this honorable court for 2 years, which was, my lord, existing.
And my lord, it was removed. And same subject matter was admitted by the municipality before the learned single judge. That is what, my lord, the learned single judge has rightly pointed that, yes, it is existing from the back. It was given way back in the year 2011 itself. So, my lord, the pipeline which was existing, my lord, it was removed. That is not permissible, my lord. It is, I am not asking new one. On merits, my lord, it is decided and everybody was, my lord, present before the court. Length hearing has been given by the learned single judge. And after that, my lord, appropriate judgment has been passed. So that, my lord, my humble submission, at least, my lord, Dasra, in the Dasra, I can reopen my canteen, my lord. I have a girl, aged about 27 years, my lord. At least, my lord, after 6 months, my lord, it is a great, I can earn for my livelihood by doing only coffee, tea, and, my lord, dosa. That is a very small canteen, my lord. Your lordship may kindly see that. This was the, my lord, pipeline. It was existing. It was moving towards the drainage. It was under the drain and to the manhole. However, my lord, same has been removed forcibly. This is the, my lord, building. This is the car parking area, my lord. Temple is not before the any court, either before civil court or before this honorable court. A trust who has made for the collection of car parking. My humble submission before this honorable court is that, my lord, at least, my lord, one connection if you will give, my lord, subject to the outcome of the, my lord, at least I can reopen, my lord, my canteen for a moment, my lord. Please, my lord, that is a humble request before this honorable court.
What did you write last? On 24th of October, full stop, not even if the office objections are not removed in the appeals, they shall be posted for hearing, looking to the urgency pressed by learned advocate for the petitioner complaint. 24th.
Please.
Number 89, Satish KM, the 230 matter.
I appear for the accused, my lords. On the previous occasion, 19/9/2024, we had filed a memo. This pertains to entitlement of 2% revision to certain employees. On the previous occasion, we filed a memo stating that 18 of those 32 employees are entitled to it. And now we have filed a compliance affidavit with the remaining 14, which is directed to be placed on record. These 14 have been rejected because they did not meet the target. So, my lords, as per the previous order, we have placed it on record and we have complied with the order of the.
Madam, we have been served with the copy of the, my lord, affidavit. My lord, we want to go through it and may kindly be called after case.
It's been fully complied, my lords.
No, my lord, we will.
That is the only limited
But,
purpose it was posted for this day.
Place some materials also, my lord, subsequent developments. Kindly have it.
In contempt, that may not arise. my lords.
After vacation, one date may kind.
As said, nothing survives. 21st of to be listed at 2:30.
Great.
Please.
Seal number 90, Vishwanath Sabrat.
Appearing on behalf of Your Lordship. This matter was with regard to New Year celebrations at MG Road, Your Lordship, which happens in Bangalore. It is infructuous as of now. The only two grounds we filed this writ petition was that one being COVID-19, Your Lordship, and the second being there were incidents in the past few years, which is page number 45, Your Lordship, if Your Lordship would peruse. There were quite a lot of harassments of women, and page number 54, page number 45, Your Lordship. These are the only two grounds on which we told proper security needs to be provided, and only these two observations may be made, and the petition may be disposed of. 54 and 55.
My lord, as on date, nothing survives, considering the fact that the date has gone by on 31st December 2023.
This is of 2016.
That 23, my lord, 31,
23.
12, 2023. New
There was
Year
a past
celebrated.
incident in 2017, your lordship. After that, there were continuous incidents which happened 2018, 19. Those were annexed along. On those basis, we had filed our representation seeking proper protection.
The prayers may be seen, my lord.
The present public interest petition and the subject matter thereof are based of two main planks, ELA and KS. First part of the grievance of the petitioners is that at the specific locations in the city of Bengaluru, a large gathering of public converge, which pose serious danger not only to public safety, but during the COVID-19 times, it has perilous effect. In that context, it was prayed that New Year celebrations should be suspended, should be directed to suspend. The second part of the grievance was that on the day of New Year celebration, on the public road and on the public streets, the youngsters congregate and in the guise of celebration, misbehave with the girls and ladies, and that there was a mass molestation. The petitioner made a representation at that time to draw attention of the said, above the said allegations requiring the law enforcement agencies to ensure the maintenance of law and order. It is in the context of the above premise that the petitioner have read in this public interest petition to direct the respondent authorities to consider their representation, which was dated 23/12/23. It was the next prayer to direct the respondents to respond authorities to implement the standard operating procedure of the central government to ensure the law and order. It was the further prayer not to allow the public gatherings or celebrations of the New Year Day, which was 31/12/2023 at MG Road, Church Street, Brigade Road, Commercial Road, etc. in the city of Bengaluru until the control of rise of COVID-19 pandemic is ensured. Further prayer was to direct the authorities, in particular this 1/226, not to allow the huge gatherings like marriages and social gathering. The last prayer was to direct respond 5 to 6 not to give 5 and 6 not to give permissions to any of the restaurants, bars, etc. Paragraph. Evidently, the grievance is related to the New Year celebration and gathering of public at the public places, at the gathering of the masses at the public places. And to complain that since it was a COVID-19 pandemic period, the gathering should be prohibited. Allegations were sought to be leveled above the misbehavior of the masses at the public places. Full stop. Judicial notice can be taken that the COVID-19 pandemic has waned and is formally declared to be. Is declared by who? Is formally declared to be not in currency. Full stop. The subject matter of petition, since related to the year 2023, no more survives for consideration. Full stop. Expecting that law and order agencies shall discharge their duties on all such occasions in future, the proceedings are closed. Disposed. Hoping that the law and order agencies.
Serial number 86. Some
86.
86, my lord. Office objections are complied. There is one office note that we have submitted, requires to be heard. It's challenging the order of the learned single judge.
Yes, it is for office objection.
No, office objections are complied. And one office objection which is raised, we have we have submitted a written submission on that. If I may request your lordships to post this matter on Monday, I will submit for 5 minutes, my lords. It is challenging the order of the learned single judge where the interim order is not, my lords, appreciated on merits. And my lords, it is
after holidays.
Otherwise, the very writ petition itself will become infructuous. That's
Fine.
the two grounds. Well, it is challenging the notification, the proceedings before the KIDB authority, 3 items are, my lords, acquired. And with respect to item numbers 1 and 3, the SLAO has released the compensation amount to a third party who is respondent number 9 in this appeal, on the understanding that if at all in the suit pending consideration, if at all there is an adverse order, she is liable to return back the amount, and he has released the amount. Insofar as the item number 2, my lords, notification is passed and proceedings are pending consideration.
Page 45 is the order.
Please, my lords.
You got the papers?
Yes, my lords.
Page 45 is the order.
That's right. Page 45 is the order.
Then
My
what
lords,
is, what is the urgency?
urgency is, my lords, 2 things. The 2 things, my lords. One is, my lords, if at all the SLAO releases the compensation amount, like similarly done with respect to item.
Why we have filed appeal against this order?
Please, my lords.
Why we have filed this appeal against this order?
Please, my lords. The other ground is section 63 bars. Section 63, there is
Appeal is filed.
appeal is filed challenging the, my lords, the interim order not being passed, not being considered on merits. My lords,
Where is the interim order not considered on merit?
please, my lords, I have submitted on my grounds itself.
No, where is the order not?
There is
refusing
no,
it?
there is no,
Where is the order refusing interim relief?
my lords, this is the page 45 is the order. My lords, your lordships are right, this is the only order. We have submitted, my lords.
The only order
this is
as
the-
was admitted by learned advocate for the appellant, Mr. So-and-so, sought to be challenged in this writ appeal is the order dated 25/7/24, passed by learned single judge. Full stop. The order reads as under. And quote this order. Learned single judge received notice and directed to post the matter immediately after service of notice. Full stop. No cause arises for the appellant to challenge the order of the kind and nature above. Full stop. The writ appeal is thoroughly misconceived and is dismissed. Full stop. It is observed, however, that as and when the writ appeal is petition is taken up by learned single judge, form it will be open for the appellant petitioner to urge all contentions and seek all reliefs as may be available in law, in accordance with law.
Great.
Serial number 25, any shorter date, because it relates
Serial number?
to serial number 25, covered by a judgment of this honorable court. Therefore, my lord, I know, my lord, in hardly 2 more days, I understand immediately after the vacation, my lord, if it is possible next week, otherwise, my lord, immediately after. The
What is the point?
what has happened is, my lord, they have, my lord, the ABC category of mines, my lord, BC and category of mines, they were, my lord, given for auction. And the auction notice itself says that, my lord, all the permissions, my lord, will accrue to the benefit of the purchaser. What they did was, they did not give me the forest clearance. Resultant position was I had to apply again. And, my lord, that there was a delay, so they levied fine. It's not
21st.
any earlier date.
Any earlier date is 16.
Please, my lord. Yeah.
My lords, may I
Sorry,
mention, my
made this
lords?
submission.
No, no. Yes.
My lord, serial number 85, my lords. My lords, in connected matters, notice has been ordered, my lords, and same matters are listed today, my lords. At
25.
85, my lords.
80.
85. The connected matters are listed at serial number 59, my lords. Veterinary University matters arising out of common judgment, my lords. Notice was not ordered in this matter, my lords.
So
85.
notice returnable on? Notice to be heard with writ appeal number?
My lord, serial number 59, my lords. Writ appeal number 1084 of 24. 1084 and 1096 of 24.
Number 78.
Please, oblige.
78, my lord. There is a office objection, my lord, with regard to, Z1, my lord, annexure Z1 and Z16, my lord. We are not relying on the documents, my lord. Maybe overruled, my lord. The objection is, my lord, newspaper publication.
Learned advocate states that the office objections in relation to the documents raised. Learned advocate Ms. So-and-so stated that the office has raised the objections in relation to certain documents which she will not rely on in course of the submissions in the matter. In that view, for the time being, the office objection are dispensed with. The petition may be listed. No, notice may be listed on 4th November.
One submission.
Notice can't be issued without hearing the.
Serial number 40, my lord.
Serial number
40, my lords. Notice has been issued. Serial number 40, my lord.
14.
40, my lord.
40.
40.
Yes.
The respondent is willfully not accepting the notice, my lord. Respondent, my lord. Notice has been issued to his residential house, my lord. His father is saying that he is not present in the house, my lord. His father is submitted.
Take your steps.
One submission, my lord. The same parties are agitating for the interim maintenance in the criminal RP, my lord. He is represented by the advocate therein, my lord. I may be permitted to serve the advocate.
We are not permitting. You do whatever is permissible in law.
Grateful, my lord.
Serial number 45. Your two
40.
submissions, my lord, they have raised an objection, saying that office has raised an objection that copy has been served through email. Physically, I will serve the copy on the other segments.
Office objection is dispensed.
And
The
one more submission.
petition, contempt petition will be listed after vacation.
Two submission.
In the week beginning from 21st of October.
My name, instead of, I appear for A3, it is showing as SHA instead of SAI.
Learned advocate, Mr.
SAI.
So and so stated that there is a mistake in this, in mentioning the spelling of the name. Full stop. The Registrar General is directed to institute an inquiry.
Otherwise, I will not know my lord.
Go to the office and get it correct.
Please do.
Serial number 54, serial number 54.
What do you want?
More retirement file, my lord. I have appearing in this matter. There is a urgency, my lord, after vacation immediately.
After vacation, 22nd of.
Shorter than.
Shortest possible.